my court officer. I will check. You can consult with my court officer on Monday. It will be, you will get the date. All. Whatever the mentioning you give to my court officer, if reason is there, I will consider.
Tomorrow, my lord.
That I will see to that.
Lordship, shall I record and give it to?
Without reasoning, I will not allow any. I think
I will record and
I will see the reason is there to add the your to include your case in the list. Then I will see to that.
One new application is filed, Lordship.
Whatever it may be, if the reason is there, I will allow. Otherwise, I will not. I will not waste the time for taking all the submission. You give all.
I will.
Money has been stuck. Money has been stuck because I was.
Give whatever the reason you record your reason in the mentioning slip. I will consider all these things.
Blocked, my lord.
Give all your mentioning slip be given to the. I will consider the reasons. If I find, I will allow you.
My lord, correction of order.
Give whatever it is. Give. You have mentioned that.
Yes.
Yes. Give. Whatever the urgency, give the urgency mentioning in the slip.
Your Lordship, for withdrawal of the proceedings.
Mention the withdrawal.
Yes, Your Lordship.
Lordships, slightly unusual request. Similar matter, Milord, concerning the same petition has already been listed on the 12th. The facts are almost identical. Milord.
Mention that.
Milord, we'll mention it.
Mention it.
May I beg mention?
I already said that. Whatever the urgency, mention your mentioning slip.
January.
Huh?
Matter is supposed to come on 20th January.
Okay, I will see to that. Give mentioning list. Give. Yes, on the list.
I apologize, my lord. May I, my lord? One, my lord.
Lordship, I am for the respondent number 224. Item number 1, Your Lordship.
Give it to me in the chamber. Mentioning, you give it to my chamber, I will see.
My lord, only one query, my lord. May I, my lord, be permitted? My lord, one issue, my lord. How will we find out whether our matter mentioning has been allowed or not? That's the doubt I have. Because, my lord, the urgency is 14th of February. My lord, is last day.
I'm led by Mr. Kejriwal. Yes. Why it is mentioned?
My lord, 14th, my lord, show cause notice issued for blacklisting my company, my lord, by DVC. My lord, 14th of February is last date to respond to the blacklisting, and my lord, we will show from the conduct of DVC that they have, my lord, preconceived mind to blacklist. My lord, that is why 14th of February, my lord, is the last date. My lord, if the matter is not listed before that, my lord, I will be blacklisted, and my lord, it will have repercussions on all the tenders that I have applied. My lord, Supreme Court has settled the law that because of failure to execute any contract, there should be no blacklisting. And my lord, I will show that their show cause notice is primarily based on
to the mediation.
My lord, no mediation, my lord, no mediation. Only show cause notice issued to black. My lord, this is 2526. Writ petition 2526.
The notice issued by the mediator fixing the date on.
My lord, writ petition 2526.
My lord, it is mentioning another writ petition. The lordship is having some other.
Writ petition 2526.
No, number. Kindly see the number 1. My lord, it is not item number 1. Kindly see the item number. Item number 1 is called.
My lord, I am for the petitioner. My lord.
Lordship, I am for the respondent bank, Your Lordship.
My lord, may I submit? My lord, from the order dated 3/10/2025, my lord, the Honorable High Court has directed that the parties are directed to appear before the learned mediator.
Correct.
And my lord, after here it is categorically stated in the mediation report that after several notice, the answering respondent 2, 3, and 4 has not appeared, and the mediation has failed, my lord.
Mediation failed, yes.
And accordingly, my lord, I have given a contempt notice to the respondent.
What contempt?
For the failure of the mediation, and they have also.
There is a contempt.
Yes, my lord, and there is a. Also, they have replied, and they have.
They will not.
My lord, in this matter, you are willing to.
If they will not come to the mediation, there will be any contempt.
My lord,
I advise you.
I have relied. my lord, to
Lordship,
this
we are
area,
willing
my
for
lord.
the mediation, your lordship. There is no deliberate violation on the part of the bank, your lordship. We have given them a letter
Ah.
that my client is ready and willing to appear before the mediator, your
My lord,
lordship.
I have submit that letter, my lord,
Hmm.
and my lord, without prejudice to my client and not and without waiving the admission of non-compliance, my lord, I pray that that if there can be, my lord can allow to reopen the mediator, then my lord can.
They are not appearing. What can be done?
Lordship,
my
we will appear. We will appear, your lordship.
Fixing a date before the mediator, your
L-
bank will appear.
Lordship, we will appear.
When you will appear?
Lordship may fix any date, your lordship. Bank is present with me, your lordship. We will
The
appear.
matter is listed as to be mentioned on the prayer made by the
My
counsel
lord,
for
the
the
petitioner should be
petitioner.
given liberty that failure to
Petitioner.
attend the mediator.
Counsel for the petitioner submit that by an order dated 3rd of October 2025. This court has referred the matter to the mediator. Full stop. The learned counsel for क्या बोला? The mediator, but the respondent bank failed to appear before the mediator. Accordingly, the mediator has issued a letter on 29th of November 2025 stating that despite issuance of notices, the respondent number 2, 3 and 4 have neither appeared personally or through their representative. Accordingly, it was held that the mediation failed.
Union of India already appeared, maybe.
Two
Yes.
failed. Now, when today when the matter is called, common learned advocate appearing for the respondent number 2, 3 and 4.
Lordship,
My
2, 3 and
Means
4.
that the bank is ready to settle the dispute and to appear before the mediator. In view of the submission made by the counsel for the
My lord,
bank, yes,
my lord, a liberty should be given that if they fail to comply the order, then my lord, the
correct.
petitioner.
Fixing a date here.
Yes, problem.
Who is the mediator? Mediator was not appointed here.
Yes, my lord. The mediator is advocate Shandeep Mukherjee.
By the 3rd October, any order was passed. Specific mediator.
No, my lord, it is to the mediator and council.
क्या बोला? Made by the counsel for the bank, comma, the matter is again referred to the mediation, and the respondent number 2, respondent bank is directed to appear before the mediator when the bank will receive the notice. Full stop. Let the matter appear. Let the matter appear on 24th of March 2025 for a report by the mediator.
My lord, oblige, my lord, kindly, my lord, have the liberty that if they fail to
Naturally, go through the mediation.
oh,
Grateful,
oblige,
your
my
lordship.
lord, oblige.
Grateful.
Yes.
Your Lordship, there was a direction to file a report. We are
My lord,
filing the report. I was humbly praying that it could be, we'll file the report today and keep it tomorrow for the hearing.
No, my lord, I'm ready to, but interim order is still today. My lord, this is a matter. My lord, petitioner is a registered licensor with the railways, and in that capacity, my lord took part in one auction which has been conducted by the Eastern Railway for an allotment of parking facility at Dakshineshwar railway station. Petitioner bid was found the highest, and accordingly, my lord, he was declared as the successful highest bidder, and acceptance letter was issued. And earnest money which was deposited was converted into security deposit. Thereafter, my lord, without intimating us, my lord, they all on a sudden floated a fresh tender. I made a representation saying that you are under the provisions of the tenders and all the freight marketing circulars, you are duty bound to execute an agreement with us. And citing no reason, you have cancelled, you have floated a fresh tender. Now, my lord, on the basis of my representation, they have cancelled my bid on 30th, which is the subject matter of challenge. And my lord is well aware of Section 5 of the Indian Contract Act that once an acceptance is being made, it cannot be revoked. My lord, it can be revoked provided the acceptance does not reaches me or acceptance is not acted upon. My lord, thereafter, my lord, I have filed this. They have the tender which they have issued. My lord, that was withdrawn without citing any reason. Now, my lord, in the report, I have preferred this writ application, my lord. On the previous occasion, lordship restrained the railways from floating any fresh tender. Now, my lord, only the defect, from the report it appears that, my lord, why the railway has to cancel the bid is because of the reason there was a minor technical error The Roshi was of the view that it could have been easily corrected through by way of an corrigendum. But they have stated in their report that they are so much helpless that that it's an automated IREPS portal. Even minor error cannot be rectified. Accordingly, my lord, they have stated that it cannot be done. However, a contradictory statement was made that the earnest money which was converted into security deposit, that can be manually, my lord, given back to me. But the fact remains is this, my lord, if the faulty IREPS portal is to be believed, then that will going to, my lord, contravene not only the statutory provisions, but also the, my lord, the regulations under which the tender has been floated. So my respectful submission, my lord, the IREPS portal cannot be relied upon because they themselves have stated in paragraph 7 and 8 of their report. If your lordship kindly goes to the report once.
Yes.
But whatever we have done, my lord, we have done within the periphery of the tender conditions, my lord.
What?
Tender conditions.
Where is the tender condition?
Yes,
Which condition you are relying
Kindly,
upon?
kindly come at page 16, my lord.
16 years.
Yes. Paragraph 17.2.
17.2.
Yes, my lord, I am reading.
Yes.
By railway administration, railway shall have the right to terminate the contract agreement without any financial repercussion on either side for any reason whatsoever after serving 1 month's notice to the contractor. Railway shall also reserve the right to terminate the contract with immediate effect without any financial repercussions on either side. On either side, in case of operational exigencies or in cases where the asset for which the contract was awarded is not available for the commercial exploitation due to some other development or change in site or any other reason. Full earnest money deposit or security deposit and lump sum freight rent license fee paid by the contractor shall be refunded to the contractor without any interest. This is the terms and conditions of the contract. Knowing fully well and agreeing these terms and conditions, the petitioner participated in the tender process. Now, it has been found that one mistake has been cropped up regarding date.
Can a condition imposed in the tender condition arbitrary? You can cancel the tender only because of the date, because the date can be considered as an corrigendum. Yes.
Corrigendum is not permitted in this case,
Very
Yes. Yes,
very sure.
Yes, page
Corrigendum is
14.
not
Can you see
permissible.
page 14? Page 14 of my report.
That I have read. Show me the condition. The corrigendum cannot be made in terms of the condition which has been given.
So far, the e-procurement system, we don't have any such provision. He is leading.
There's a peculiar situation, absolutely peculiar situation.
Yes.
But
Peculiar situation, simple situation.
no, actually, what happened, these are all maintained, absolutely, automated portal. In the automated portal.
Automated portal, it's okay. I am totally agree with you.
Yes.
After one corrigendum, it cannot be published in the website.
No,
we
tried it.
Sir, can I record this and I will appoint a special officer. The corrigendum cannot be uploaded online. If you record, if you say that, I will record your submission and I will call the IT personnel and I will take the report.
May I just place 3 paragraphs?
Yes.
Kindly take my report in the form of affidavit,
Yes, I have gone through the total report. Which paragraph you are reading?
Total report. Kindly take paragraph 7, page 3.
Yes.
It says, upon discovering the error, the railway administration
Where paragraph?
Paragraph 7,
Paragraph.
page 3. Upon discovering the error, the railway administration promptly explored all the avenues for correction. A formal query was raised with the IREPS portal authorities, query ID number seeking a solution. specifically inquiring if the contract start date in the bid sheet could be corrected. The official and the conclusive response from the IREPS.
What is the IREPS?
IREPS, my lord, it is, my lord, Indian Railway e-procurement system.
Okay.
Indian Railway e-procurement system. The IREPS was received. The CP start date cannot be changed in bid sheet stock contract. A copy of the query is R2. Now we'll kindly see R2, page 14.
Page?
Page 14, 1-4.
1-4.
Yes.
Yes.
Like, has also got it.
Yes.
Query is, my lord, an auction has been conducted for an for an assistant after completion of the auction. Bid has been received from the such and such. After signing the said bid sheet, it has been noticed that the contract start date had inadvertently been inputted in the e-auction lot on IREPS portal on as 2/11/2026 instead of 2/1/2026. For this issue, the contract agreement has not signed. It has come to the notice that when the cancelling bid, that there is no option of cancel of bid with refund of EMD. Please suggest me what action to be taken to resolve this issue. The answer is not there, sir. CP start date cannot be changed in the bid sheet or contract. This is the answer given. Now kindly text page 4, paragraph 8.
Yes.
That the IREPS system is a fully automated digital portal designed for e-auction without provisions for manual intervention post signing of the bid sheet, especially for the core commercial terms like the contract start date. There exists no functionality within the system to issue the corrigendum or unilaterally amend the signed bid sheet. Therefore, the respondents could not issue the corrigendum to amend the date. Was not a technically feasible option. Now, next paragraph 9. Faced with this technical impossibility and considering the paramount public interest in ensuring the continuity of the essential passenger amenities without an 11-month hiatus, the railway administration was constrained to take decisions to cancel the bid and terminate the contract process. Now, the problem is, my lord, so far as, my lord, there is a mistake on our part. There is no doubt. Now, my lord, it has become a irreversible mistake. Second issue. Third point is, my lord, that so far as contract is concerned, my lord, I cannot even give contract, my lord, for 11 months or 10 months. The contract has to be for 3 years. Now, the problem is, my lord, so far as this period is concerned, from January or from January to, my lord, November or October, January to October. Well, for this period, my lord, I have to make an alternate arrangement. Now, my lord, so far as this period is concerned, my lord, I cannot put any tender also. Kindly have a look, my lord, page 26 months.
26 of?
26 of
Report. 26 of
yes,
report?
yes.
Yes.
Now, my lord, can you see, my lord, clause 8,
Yes.
page 26. The duration for commercial earning in RF contract shall be as following. The contract for leasing a parcel space for 2 years, the other commercial earning or NRF for 3 years. Now, my lord, this is for 2 years, 3 years, 5 years, 10 years, 15 years, and all these things. So, my lord, so far as this period is concerned, this is, my lord, for the period of January to, my lord, October. This contract is, my lord, effected on and from 2/11/2026. But I am facing the problem from January to, my lord, October. Now, my lord, I am not, my lord, saying anything, my lord. My lord, this is my fault. There is no doubt. And, my lord, so far as reversible portal system is concerned, my lord, this has been done, my lord, for the purpose of curbing, my lord, on all kind of fraudulent activities. It is a portal, my lord, created, my lord, with a specific design.
Yes.
Now, my lord, these things has happened. Now, so far as, my lord, EMD is concerned, my lord, I am ready to refund the EMD. There is no doubt about that. Now, my lord, one solution, my lord, I'll subject to your lordship approval, my lord. But I am not standing in the way. But my hands are tied. But it can be solved by your lordships. Well, so far I had taken instruction, well, so far as corrigendum part and all these things. That's why, well, the specific stand had been taken by the railway authority. Railway authority is not in a position to issue the.
How many persons have participated?
How many?
How many persons have been participated in the tender?
How many persons participated? Exactly, you don't know. I don't have any
May I
instruction.
say one thing, madam? Subject to lordship's kind approval. If your lordship ultimately so desires, I can start my contract. If they allows me ultimately, as per your lordship's direction, from next week also.
No, no.
No, well,
Problem is that they have, as per the contract, November 26. That's why the might be the other contractor not in a position to participate in the tender. Once
Now,
it has been come to the this started from the March or February, there might be the other contract.
can-
That's why I put the specific question: how many tenders have participated in this tender?
My lord, before you, sir,
Okay.
if your lordship kindly come to page 28 for once.
28 of?
28
Of?
of the writ application.
Hmm.
Kindly see, my lord, 28 before clause 3.1.
Hmm.
If I lordship allows me to read,
Yes.
the auction catalog containing all the lots proposed to be auctioned off on a given date and time, and the terms and conditions applicable for the auction catalog shall be published minimum 15 days in advance of the auction start date.
Correct.
Complete details of the lots and assets included in a lot will be included in the auction catalog. Contractor will be able to check the lot specific financial eligibility on IREPS at least 7 days before the start of auction.
Correct.
So, my lord, from the date of publishing of the auction till the auction date, 15 days window was there to identify the simple arithmetical mistake, my lord.
No, that's why they have admitted.
Yes.
It is not that they have not they have admitted and they have already taken a steps for correction of the date, but they have received the reply, but it cannot be corrected. But it is the online e-tender, so date cannot be. Now the question is that as in the tender it is mentioned 2/11/2026, but the tender should be 2nd January 2026. This 11 months is there. So might be the other contractor who are eligible for the set participating in the set contract might not have been appeared because they thought in November what will be happen, so they might not have been appeared.
My lord, probably may I say this to this question, my lord? My lord, a very relevant, pertinent point has been raised. My lord, so far as these FM circulars are concerned, there is no provision of allotment of this particular contract or for the inter-income period to any of the bidders, except to the successful bidder. Now, when the successful bidder has stated in its exception that if your lordship so desires, he can operate.
No, you can operate because you are the benefited person. You will operate, but the problem is that the other persons who also having a qualification but not participated in the tender due to the date which is in November. Why the contractor will say invest the money for the for 11 months, keeping the 11 months pending?
My lord, may I say to this? My lord, what the railways have stated that the asset cannot be remain kept idle. There is a loss of revenue. But in on site, my lord, I have annexed proper document that the railway is continuing with the parking lot business.
No, this is not
My
a
lord,
railway.
may I say this? My lord,
No, the court is not going on that. The court is on the only the point before this court whether the date of starting of the work can be treated as the 1st January, 1st February or 2nd January 2026, though in the tender document it is recorded as 11th February, 11th January,
Second
November
November.
2026.
my lord, clause 8, if your lordship sees clause 8 of the provision, it's very clear.
Where is
Kindly
that?
come page 30. Page 30. Clause 8, last paragraph. If it is of any assistance to your lordship, the provision is very clear that the successful bidder shall be required to execute an agreement with the President of India acting through the auction conducting officer. The contract agreement duly signed by the auction conducting officer will be delivered to the successful bidder online, which has been done.
Correct.
Which can be accessed by the bidder through his IRES user account.
Yes.
The bidder will have to sign the contract agreement within 5 days.
Correct.
From the date of receipt of the same.
Correct.
Contractor will have to sign digitally by both the auction conducting officer and the bidder. If the bidder fails to sign the contract within 5 days of receipt of the same, the auction conducting officer may at his discretion cancel the allotment of the lot
Correct.
to the bidder and forfeit the earnest money deposited by the bidder. If they, my lord, generates me the agreement, I can execute this agreement right now.
That is not the question here. They are not telling. Here only the question is that how the date is to be preponed for 2nd of January 2026 instead of 2nd November 2026.
This
That
can be through a judicial intervention, my lord. Because if the rules
court
are
can
silent on
court
this,
cannot take the risk in the hands.
if
Sir.
the rules are silent on this, my
Not rules are silent. It is the mistake on the part of the
But for that,
authority.
I cannot
So-
suffer, my lord. I have done everything.
You have not been suffered. You will be able to participate in the
But fact remains is this, my lord. If the system is allowed to continue, then it will have a cascading effect of so
No,
far
no.
as the provisions of statutory
The
provisions are
petitioner has
concerned.
filed the present writ application. Present writ application. Challenging the order. Where is the order?
Order is at page, my lord, 55 of the writ petition.
Challenging the order dated 30 December 2025 issued by the Senior Divisional Commercial Manager, Eastern Railway, Shelda, wherein where is the impugn order?
Page 55, my lord.
55 is the cancellation.
Page 55, my lord, is the cancellation of the bid, which is a subject matter of challenge, which was issued in contravention to Section 5.
Wherein
the Indian
the
Contract Act.
authorities have cancelled or terminated the tender process of parking Shalda deck MK 65 25 1 at the Kineshwar on the ground that after signing of the bid sheet, the authorities have noticed that the contract start date has been inadvertently been inputted in the e-auction lot on IREPS portal as 2/11/2026 instead of 2nd January 2026. Full stop. The counsel for the petitioner submit that in terms of the e-tender notice issued by the respondent authorities, the petitioner has participated in the said tender. And after opening of the tender, it was found that you are the highest bidder or lowest
I
bidder?
was the successful highest bidder.
The petitioner is the successful highest bidder. But subsequently, the authorities have terminated the contract on the ground that in the contract document, the commencement of the contract is mentioned as 1/11/2026 instead of 2nd January 2026. Police. Counsel for the petitioner submit that this is the only a typographical mistake with regard to the date of commencement of the contract, and the same could have been corrected by the authorities by way of a corrigendum stating that the contract work will be commenced from 2nd January 2026 instead of 2nd November 2026. Police. This court has called for the report from the authorities, and the authorities have filed the report by way of an affidavit. In the affidavit, it has been categorically, in the report, it is categorically stated that upon discovering the error, the railway administration promptly explored all avenues for correction. A formal query was raised with the IREPS portal authorities, seeking a solution, specifically inquiring if the contract start date in the bid sheet could be corrected. The official and the conclusive response from the IREPS was received as CP start date cannot be changed in bid sheet /contract. Full stop. Learned counsel appearing for the authorities submit that IREPS system is fully automated digital portal designed for e-auctions without provision for manual intervention post signing of the bid sheet, specifically for core commercial terms like the contract start date. It is further submitted there exists no functionality within the system to issue a corrigendum or unilaterally amend the signed bid sheet, due to which the respondents could not issue a corrigendum to amend the date of the commencement of the contract work from 2nd January 2026 instead of 2nd November 2026. Full stop. Learned counsel appearing for the petitioner submits draw the attention of this court to clause 3.1 of the tender document and submits that as per clause 3.1 of the tender document, the auction catalog containing all the lots proposed to be auctioned or of a given date and time, and the terms and conditions applicable for the auction catalog shall be published minimum 15 days in advance of the auction start dates. Complete details of the lots and assets included in a lot will be included in the auction catalog. The contractor will be able to check the lot specific financial eligibility or IREPS at 7 days before the start of the auction. By referring the said clause, learned counsel for the petition submit that the respondent authorities have 15 days time in their hand, but the respondent authorities failed to correct the same before publication of the said tender, and as such, this is only a clerical error which can be corrected, and the petitioner is ready and willing to execute the agreement and to start the work as and when the respondents will allow the petitioner to execute the work. Full stop. Heard the learned counsel for the respective parties peruse the materials on record. The short question in the present date application is that whether the commencement of the date which was provided in the original tender document can be changed by the authority after publication of the after opening of the tender process. In the present case, at the time of finalization of the bid, the authorities have found that the work is to be commenced from 2nd of January 2026 for 5 years.
3 years.
For 3 years. For 3 years, but inadvertently in the tender document, the commencement of the date of the work has been mentioned as 2nd November 2026. This from the report submitted by the authorities, this court find that when the authorities have discovered the said discrepancies, have made several attempts for correction of the date by way of corrigendum, but it was advised by the concerned author. Who has advised? It was advised to the respondent authorities that the IREPS system is fully automated digital portal designed for e-auction without provisions of manual intervention post signing of the bid sheet, specifically for the core commercial terms like the contract start dates. As it is also informed that the CP start date cannot be changed in the bid sheet of contract. Considering the above, this will find that the respondent authorities inadvertently recorded the date of commencement of the work from 2nd of November 2026 instead of 2nd of January 2026, and when the respondents have discovered the said discrepancies have made endeavor for correction of the date by way of corrigendum, but it was found that it is not possible for the respondents to correct this date. Accordingly, this court did not find any malafide and arbitrary action on the part of the respondent authorities. It is found that the petitioner have already deposited the EMD, but the authorities have terminated the tender. The authorities are directed to refund the
And
EMD.
he is to submit
My lord,
all these
may
documents.
I say to this only?
Well, can you have page
Seconds,
21?
my lord, kindly few seconds. Lordship has recorded that automated system, it cannot be intervened. Kindly come to page 14 of the report. What we have stated absolutely contradicts this stand.
Yes.
That it is submitted that while processing the cancellation of IREPS portal, it was observed that the system by its default programming marks the EMD as forfeited. And to safeguard the petitioner from any financial loss and to comply with the mandate of clause 72, immediate steps were initiated to manually override the system and process the refund of EMD. So if they can manually override this system to process the EMD, they can also manually override the system to change the date. This is my submission, my lord. I will not do it.
Petitioner क्या बोला? Refund the EMD to the petitioner within a week from date.
Well, he has to provide certain information, Lord. Page 60. Bank details, cross check, and all these things. Provided he provides.
Subject to providing the all bank details where the EMD is to be refunded by the authorities.
Yes.
WP is dismissed.
Deeply obliged. But I am really sorry to my learned friend also. Really sorry.
What can be done?
This is the absolutely irreversible thing.
Not paying because apology, my lord. I had just come late, my lord. But this is a serious matter which need to be heard by your lordship at an urgent basis regarding the election process, my lord.
Which election?
Not that means the electoral roll. My lord, in 2019, I was the voter of Beechpur constituency. Beechpur constituency. I had cast my vote. After that, I was implicated in a criminal case. In 2024, I was enlarged on bail by this Honorable High Court with the direction not to enter into the jurisdiction of Beechpur police station. Now, after that, this year, during the process of SIR, I had came to know that my name was deleted from the electoral roll.
Go to the concerned authority.
Yes, my lord. After that, I had applied. I was called for hearing under the jurisdiction of Beechpur PS. I had made a request to the DEO to.
So what you prayed for before this court? What do you want?
They are now what they had done. The DEO had given a date at the DM office for conducting the hearing. It is on 29th of January. 31st, they had again, due to the lack of staff, they are not able to conduct the hearing on the DM office. He was further directed to attend the Beechpur within the jurisdiction of Beechpur police station, which was diverted from by this honorable High Court.
What you want? I don't want our story
I just
here.
want to direct direction upon the DEO or the election commission to give another chance to attend the hearing.
You might not have been appeared before the authority.
This is under the Beechpur police station, and the honorable High Court has restricted me to enter within the jurisdiction of Beechpur police station.
By which order? Why you have been restricted to?
I was implicated in a criminal case, and I was enlarged on bail.
So you could have been taken the leave from the court to go to the appear before the authority.
My lord, that has been
which court has imposed the condition upon you?
My lord, the bail bench, my lord. Justice Arijit Banerjee and Justice.
Yes, go and take the leave from the court for modification of the bail or condition of the bail order.
The matter was disposed of, and today is the.
Why? If the matter is disposed of, why you can file an application for modification of the order?
I have to file a CRAN application.
Yes.
But the matter is that today is the date for hearing.
Which?
Of the electoral roll.
Today, what can be done?
But the thing is that unless and until the matter been heard, my lord.
Sir, once one court has been restricted your movement to one place.
My lord.
Correct. Without approaching that court, whether this court can allow you.
No. I am not on the leg of that. Kindly allow me to attend within the jurisdiction of Beechpur PS. I am just praying before lordship, kindly allocate the order which was passed on 29th that the hearing will be conducted in the DM office at Barashat. Again, that has been changed.
It is the authority. They will decide which place the meeting is to be conducted, not as per your choice.
No, that was further changed On
Further
31st,
change you
my
put
lord.
up in the notice has given to you.
Yes.
So why you not appeared?
It is under Beechpur police station again.
So you could have been immediately go to the court
Again, I have made a representation before the Election Commission of India also, but nothing has.
So today it cannot be taken.
Kindly grant me leave so that it can be taken up today, tomorrow, or day after tomorrow, my lord. I will serve each and everybody, my lord.
And list the matter on Monday.
Deeply obliged.
Yes, call the next matter.
I am praying apology.
Lordship, I am for the petitioner. I am not pressing this application, Lordship. This is my written instruction.
The matter is research to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petitioner has handed over a written request of the handed over a communication dated 5th of February 2026, wherein the plaintiff has requested the learned advocate on record of the plaintiff petitioner, advocate of the petitioner, to withdraw the instant writ application. As per the communication dated 5th of February 2026, counsel for the petitioner pressed for withdrawal of the present writ application. Consider the submission made by the counsel for the petitioner, peruse the communication dated 5th February 2026, WPA number 159 of 2026 is dismissed as withdrawn.
Lordship, kindly give me the liberty to file a fresh, Lordship.
The liberty to file a fresh.
Deeply obliged, Lordship.
Communication be kept with the record. Next.
Deeply obliged.
Yes.
But on the last occasion, my lord, I had informed your lordship that, my lord, this is a recalling application with a delay of 1136 days.
Who is for the other side?
I am for the ECL, my lord, but I would like to, my lord, file a short affidavit, my lord. Because of this, my lord,
may I tell my learned friend what I told your lordship on the last occasion, that if I go into the details, I will be speaking against my own community.
I found the name, Lord. It's there, but because of that reason, Lord, of that long delay, I have to, Lord, formally, Lord, put an objection. Then, Lord, lordship will obviously.
How soon you will file?
But 10 days, Lord, I'll file it.
Let the file. The petition has filed the present application being can 2 or 1.
Okay, this is can 1.
Can 1 of 2026.
But can 1 is condonation and can 2 is the recalling.
Filed an application being can 1 on 2025 for condoning the delay of an application for recording of the order, wherein this court has dismissed the petition for default. Learned counsel for the respondents press for time to file affidavit in opposition. Let affidavit in opposition be filed within 10 days. Reply, if any, that to be filed within a week thereafter. List the matter on 2nd March.
2nd March.
Under the same.
I'm grateful.
Under the same.
Let the affidavit of service be kept on.
Affidavit of service be kept.
Next.
My lord, item number 6, I'm appearing for the contemners. My lord, the petitioner in this matter, my lord, I'm being
Your lordship, I'm for the petitioner in this contempt application. I'm sorry, I'm appearing online today. I'm actually a little under the weather, your lordship.
Yes.
Your lordship, in this matter, your lordship on the 16th of December has passed an order.
Yes.
The challenge was against various loan recalling notices by 14 NBFCs in my contention in violation of the MSME rehabilitation and policy. Now, apropos the PROCEEDINGS decision, etc., your lordship, by your lordship's decision dated 16th of December, has passed an order in my favor asking directing all the NBFCs to consider my representation in accordance with the MSME circulars and till disposal of my representation not to proceed and keep in abeyance all roll recalling notices. Your lordship's order is at page 39.
Yes.
It starts at page 39.
Yes, paragraph 23 of the judgment.
Paragraph 22 and 23, your lordship.
Correct.
22 is a direction for consideration of my representation, and 23 is the abeyance.
Correct.
All notices to be kept in abeyance. Now, in this matter, and your lordship will kindly take para 14 once. Para 14, your lordship will notice. Para 14, kindly turn over to page 46. It continues, the table continues at 46.
Yes.
Serial number 19 and 20 is Sundaram Home Finance Limited.
Yes.
They were one of the respondents.
Yes.
They were respondent number 13 in the original writ petition.
Yes.
This order was passed, and in course of this proceeding, this writ petition was filed on 25th of November. It was disposed of on 16th of December.
Yes.
Now, it was served on all respondents pursuant to a direction of the court as well. Again, I have filed the proof of service, etc. Sundaram Finance, the respondent number 13, never represented itself in the proceeding. Thereafter, we communicate to all respondents the order, and specifically Sundaram Finance, the order of your lordship dated 16th December by our letter dated 18th of December 2025. That is at page 63.
63?
63.
Yes, ma'am.
Volume 1, page 63.
Yes.
Your lordship will find at page 65, Sundaram Home Finance.
Yes.
I have marked it to them. I communicate the order in its entirety.
Yes.
Now, postal tracking receipt, etc., I have annexed. This communication was delivered.
So now what has happened? What has happened? They are not.
Sundaram Finance, after receiving this particular communication on 18th, they have addressed a 13-2 notice on 18th of December, your lordship, which is antedated to 29th of November. Your lordship will kindly come to page 89. Kindly see is
yes.
Page 89, your lordship will first see the date 29/11/2025, as if this was a previous notice. Sub demand notice, loan account 13-2. This is a 13-2 notice upon classification of my account as NPA. Now, very interestingly, your lordship, if your lordship kindly takes page 94, your lordship sees when this notice was sent. It was booked on December 18, 2025 at 5:11.
Yes.
So after your lordship's order, after us communicating,
yes,
they book this notice on December 18, item delivered on December 20th, where they purport to A, classify my account as NPA, and thereupon initiate 13-2 proceedings.
Okay.
In my submission, since this notice is antedated, which is in itself an irregularity, and since this step has been taken subsequent upon your lordship's decision dated 16th, and in complete contravention of the directions at para 22 and 23, they should be, rule nisi should be issued, your lordship, and they should be prevented in the interregnum from proceeding with this 13-2 notice in any manner, your lordship. That is my prayer at this stage.
Yes, who is for the you are appearing?
My lord, I was appearing as 56814 in the writ petition.
No, Sundaram Finance.
I have nothing
Of course,
against
I'm not
this
appearing.
petition is not. And in your lordship, another thing I must point out, we, upon receipt of this notice, we send our reply once again, stating that on 24/12 at page 103, we intimate them that, sir, your notice appears to be in contravention of the order of the court. So you must withdraw this, and this is antedated. To that, what they do is, at volume 2, then issue another letter dated 3rd of January 2026, saying that non-acceptance, treating my reply as non-acceptance under 13(3)(a).
Where is that?
Mr. Banerjee,
That
that
is
is
at page
27th.
149, Your Lordship.
That would be 27th of December, Mr.
Where is
Banerjee.
the order? Where is your where is the bank? The last reply of the bank?
Yes, Your Lordship. That is kindly come to page 149.
149.
149, volume 2, Your Lordship.
Yes.
We make a representation on 24 to once again asking them to recall, saying that this is in violation. They say non-acceptance under 13(3)(a). They don't even treat this as a notification, intimation of the contravention of the order of the court. They say, no, this is not explanation enough under 13(2). So 13(3)(a), non-acceptance.
Recorded.
They are proceeding with it.
So you all are not appearing for the Sundaram?
No, my lord, we are not appearing.
The petitioner has filed the present
My lord,
present contempt application.
my lord, another thing that I wanted to bring to your lordship's notice, there are two 13(2) notices. Both of them are antedated, my lord.
And the contempt application being CPAN 60 of 2026 on the allegation that the alleged contemner number 12 all
Yes.
are from the Sundaram Finance.
Yes, your lordship. Operating minds and agents
have deliberately and willfully violated the judgment passed by this court dated 16/12/2025. Counsel for the petitioner submitted that the judgment passed by this court was duly communicated to the alleged contemners, but in spite of receipt of the order passed by this court, the alleged contemners have issued the notice under section 13 within bracket 2 of the SURFACE Act dated 29/11/2025. But as per the postal document, it was found that the said document was booked and the said notice was booked only on 18 December 2025. That is after the order passed by this court. To further submit that on receipt of the said notice, again the petitioner has informed about the order passed by this court dated 16 December 2025. But in reply to the said notice, the alleged respondents have not accepted the contention raised by the petitioners in their reply to the notice dated 19/11/2025. The none appears on behalf of. Have you issued the notice? No.
No, my lord.
None appears on behalf of the police. This court find that by an order dated 16 December 2025, this court by an order dated this court has passed the following order. Paragraph 22 and 23. Page 54-55. The said order was duly communicated by the petitioner to the alleged contemners.
One thing, may I clarify, your lordship?
Yes.
Just for clarity, on 18th, I sent my communication.
Correct.
That communication from postal receipt, it appears, was delivered on 19th of December.
Okay, whatever it may be.
Yes, and in the meantime, on 18th, they have issued that. I just wanted to clarify.
To the petitioner. Full stop. The respondents have sent a notice under section 13(2) of the SURFACE Act dated 29/11/2025. But as per the postal document, it is found that the notice was booked only on 18th of December 2025. That is order of this court. That is after the order of this court. Even on receipt of the said notice, the petitioner has sent a reply intimating about the order passed by this court, and on receipt of the reply, the bank, the alleged contemners have sent a reply stating that that all the rights and remedies under the Surface Act 2002 of the Surface Act and the rules therein and other applicable laws are expressly and entirely reserved, and they have directed the petitioner to compliance with the demand notice dated 29/11/2020. This court finds that even assuming that the order dated 16 December 2020 was not received by the alleged contemners on or before 18th of December 2025, but in reply to the said notice, the petitioner has again informed about the order dated judgment dated 16 December 2025. In spite of the same, the alleged contemners are continuing with the surface notice. Considering the above, this court finds that the alleged contemners have deliberately and willfully violated the order passed by this court. Accordingly, rule be issued upon the alleged respondents, alleged contemners, returnable on where they are on Calcutta or outside.
My lord, they're in not in Kolkata, my lord, Chennai.
Returnable on 27th of February 2026. Police. In the meantime, the alleged contemners are directed not to proceed with the notice dated 29/11/2025 and the reply dated
3rd of January.
3rd of January
27th December, my lord.
Huh?
27th of December, my lord.
What?
Their reply under 13.3.
Not reply, their reply.
Yes, my lord.
Akanksha, their reply was on 3rd of January. That is at page 149.
But that is dated 27th December. It's on top.
Huh?
It's dated 27th December, my lord.
Just show.
Page 149,
My apologies, your lordship. That is dated not 3rd of January, 27th of December, your lordship.
149.
149 only.
Yes, my lord. Volume 2.
Dated 27 December.
My lord.
27 December 20.
My lord, another humble request. If the notice could be made notices, the antedated notices, my lord. Grateful, my lord.
Yes.
I'm deeply obliged, your lordship. Very grateful.
Grateful, my lord.
Next.
6 or 7. 6 or 7 was actually.
7 was the connected writ petition.
7 is a connected data.
Yes, as it is appearing as item, my lord.
Okay. Next.
Grateful, my lord.
Grateful.
Bid to appear on day of the petition.
My lord, this is a matter relating to, my lord, termination of service. Ashok. This is a matter relating to termination of service under Vishwabharati University, my lord. My lord, she was assistant professor.
Now, why the West Bengal? What is which case? Item number?
16659 of 2023.
Who are the respondents?
My lord, the Vishwabharati University. My arrangement is here, my lord.
Vishwabharati.
My lord.
Who has typed this? Who has typed this? You. Change karta hoga. First Okay.
Lordship, at the outset, my lord, this is second round of litigation. Initially, my lord, they have terminated me, my lord, without informing anything else. This honorable court was kind enough to relegate this matter before the appropriate authority. Then that was not passed. As a result of which, under petition and under compulsion, my lord, filed contempt application, and thereafter, my lord, one order was passed, which is cryptic and which I intend to challenge, which is impugned order.
Yes.
Prior to that, my lord, I am drawing lordship attention, page 35. That is my appointment letter. Lordship will find, my lord.
What you have prayed for?
But I am praying, my lord, the reinstatement and my lord, the salary, or my lord,
when you have been terminated?
My lord, terminated in the year 2020.
20.
Yes, my lord.
Any disciplinary proceeding was initiated?
Nothing, my lord. Nothing. That is the whole difficulty, my lord.
So where is the impugned order?
My lord, impugned order I am showing, lordship will find, my lord. Kindly come to Last 2-3 pages, my lord. Lordship will 93, 94. 93, 94. Lord, may I read, my lord?
93, 94. Yes.
My lord, but entire order, my lord, is this, my lord. Without dealing with, my lord, my written objection, comprehensive written submission pursuant to the direction issued by the first round litigation by this honorable court, my lord, they have, my lord, repeated, my lord, or inserted certain facts and figure, my lord, from their own, my lord, the record. What happened, my lord? Kindly see 93. My lord, I am leaving, my lord, first 2, 3, 4 paragraph. Then, my lord, the copy of the order cited above was received by this office by the register. Then online interaction with Mr. Vidisha Banerjee, Mrs. Vidisha Banerjee with the chairperson CFL Vishwabharati was held as per schedule. Then, my lord, third, in continuation to the online hearing, Mrs. Vidisha was issued a letter dated so-and-so asking her to provide replies, justification about the question which emerged during the online interaction.
Correct.
Mrs. Vidisha submitted her written response to the chairperson so-and-so. The conclusion drawn from the online hearing, the letter of appointment dated so-and-so, and mention the appointment was a temporary project. Yes, my lord, admittedly it is temporary project. My lord, my service will be continued till the project is, my lord, in force. The letter also mention about the probation period. This appointment is associated with the duties and responsibilities as may be assigned by the authorities from time to time. The letter further mentions the appointment as assistant,
and the appointment is associated with the duties and responsibilities assigned authorities from, yes.
Lordship. My lord, 4 days, my lord, overstay, so far her leave is concerned, was the immediate cause of action of my termination. Then, my lord, they are, my lord, certain facts and figures are there. If lordship kindly see page 94, at the bottom, paragraph 7, Mrs. Vidisha Bhattacharya's representation on question number 1 to 7 lacks of credible evidence, and most of the responses are evasive by citing lack of sufficient data and fictitious submission to the former authorities. The decision of the review committee taken on so-and-so date seems to have been taken after considering the duties and responsibilities fulfilled by the Vidisha Bhattacharya. My lord, my service was terminated without informing me that there are any lackings. I am an inefficient person, my lord. That being the situation, finally this order was passed pursuant to the direction of the contempt court. Contempt court imposed, my lord, the penalty upon them. Then they have passed this order, which is, my lord, impugned before this honorable court. Then, my lord, I may be allowed, my lord, to read the appointment letter. Lordship will find what are the terms and conditions at the time of appointment.
Who is for the authority? You are appearing?
My senior appears for the...
Mr. Shaumo Mojuddar, my lord, senior advocate.
Yes, yes.
I am placing. Page 35 may kindly be looked. My lord, in evident in opposition, they have taken a, my lord, plea that since I am not asking them to, my lord, investigate and inquire the whole issue, that is why they did not initiate the proceedings. My lord, page 35 may kindly be looked into, my lord. My lord, the undersigned is directed to offer you the appointment to the post of assistant professor. Page 35. My appointment letter.
Yes.
The undersigned is directed to offer you the appointment to the post of assistant professor temporary project under the Center for Endangered Language, Vishwabharati, with effect from the date you join the post. The payment will so-and-so, plus usual allowances as admissible under the rules of the University Grant Commission from time to time. Your pay will be fixed as per the rules of University Grant Commission project as applicable to the university. Although the post offered to you is for a duration of 3 years, or as long as the CFEL project is continued by the UGC. Well, till today, that project is continuing.
Undersigned is directed to offer the appointment of post of assistant professor under the Center of Endangered Language.
Endangered Language.
Vishwabharati, with the effect from the date you join the post, the pay so-and-so, plus usual allowances under the rules of university from the time to time. Yes.
Then, my lord, second paragraph. For 3 years or as long as the CFEL project is continued by the UGC, stop, my lord. You will be on probation for a period of 1 year, which may be extended year by year if the performance is satisfactory. My lord, I have continued there 5 years. In the year 2020, termination was taken place. This appointment.
You have now 2015.
Yes, my lord. 2015. I am showing my
All the post offered
letter of joining, my lord.
Duration of 3 years or the long as the CFSR project continued by the UGC.
But till today, my lord, it is continuing.
1 year, which may be extended hereby.
If the performance is satisfactory. So, my lord, they are come to a conclusion of objective satisfaction. My performance is not satisfactory. This appointment is associated with the duties and responsibilities as may be assigned by the authorities from time to time. Your condition of service, including leave, may be governed by the Act, Statute, Ordinance, and rules of the university as may be in force from time to time. My lord, that rules with us. My lord, I am considered there as an Odhapak, permanent, and my lord, the temporary. Odhapaks are being considered as Odhapak in Vishwabharati. You shall have to reside in Shantiniketan or Bolpur area. You will not be granted any university accommodation. You are requested to obtain fitness certificate from any registered medical officer. You are required to fill up a police verification in your handwriting to be obtained from the university administration and deposit the same in triplicate. So and so, my lord. Then, my lord, turn to the next page. And there are conditions for police verification. And particularly the verification of your character and antecedent, page 36, my lord, failing which your joining will not be accepted. Then, my lord, the last paragraph, the appointment is subject to verification of all relevant documents such as mark sheet, so and so, for your eligibility to the post.
Okay, this is the appointment letter.
This is the appointment letter, my lord.
Yes.
Then, my lord, kindly see that I have joined page 37 in the year 2015. My lord, at the bottom, lordship will find my date, 24/4/2015. Page 37, my lord, annexure P2. But the middle portion, after 34. My signature, page 37, my lord.
37, yes.
Yes, my lord. Middle portion, my signature, thereafter, my lord.
Yes.
Date of joining, 24/4/2015.
Yes.
Then, my lord, kindly see page 38. My lord, that particular letter which I have received, that with reference to the terms and condition of the appointment letter issued to you under CEFL project.
Where reading?
Lordship.
Where from you are reading?
My lord, page 38. Next page. Next page. Here, my lord, requested me to appear before a review committee on 38, page 38.
Yes.
My lord, at that point of time, I was on leave. Page 39, my lord.
Yes.
I took leave 5/2/2020 to 20th February 2020. The schedule meeting, my lord. My lord, kindly see 17/2/2020 is the scheduled date of meeting, review committee. My lord, I have overstayed 4 days because I was in Delhi for my treatment. Every document I have enclosed, that is page 40. Then, my lord, I am drawing lordship attention, annexure P641, my service was terminated.
Is your leave?
Yes, my lord.
It was sanctioned or not?
My lord, sanctioned, 4 days overstaying was there.
No, 5/2/2022 from 22.
Yes, my lord.
2020. You are on leave.
Leave.
This was sanctioned leave.
My lord, the practice of my lord Vishwabharati University is, my lord, leave application to be submitted. Post facto sanction is required to be taken place. This was taken into consideration in the first round of litigation, and thereafter quashing that order, it was relegated before the authority. But then, my lord, I am drawing lordship attention, page 41.
What is the 40?
40, my lord. 40, my lord, I was in Delhi for my treatment relating to all documents. To substantiate, for my treatment, I was there. I visited a government hospital relating to all those papers. I have, my lord, immediately communicated. That is AIMS, New Delhi, Safdarjung Hospital, and the name of the different doctor.
Okay, then what is
Then, my lord, page 41 may kindly be looked into.
Yes.
My lord, as per decision of the review committee held on 17/2/2020 and approved by the competent authority, your service will be terminated after 1 month from the issuance of this email dated 31st March 2020. My lord, this was my service was terminated. Only, my lord, before going into the first round litigation judgment, I am drawing lordship attention, page 42, annexure P7. Why they are, my lord, so much annoyed? Because at a point of time, I have raised certain question with regard to the, my lord, the functioning of this particular department. Page 42, paragraph 2.
Yes.
However, I would like to point out that I have not been part of the communication in the center regarding the recent reconstitution of the advisory committee, and I only come to know about the existence of the reconstitution of the committee through the Vishwabharati website. Thus, I am at complete dark about the charter, modus operandi, constitution of the reconstituted committee. My lord, I raise this question. The function of the committee is not transparent. It should be made in a transparent way. That was my letter addressed to the, my lord, director of that particular department. Then, Lordship, I am drawing Lordship attention. After this letter which I have received, I wrote a letter addressed to the authority to recall it and to allow me to join. That was not done. Now, my lord, advocate's letter, I have termed this, my lord, termination as punitive. And my lord, that is page 49. Most unwarranted and unpredictable, my lord. Page 49, my lord, my advocate's letter. I mentioned the word most unwarranted and unpredictable since no procedure has been followed in terminating her. Rather, it is say that termination is punitive in nature, which may cause damage to her future. My lord, my lord, in their affidavit, what they have very categorically stated, the petitioner did not make any prior submission for full-fledged inquiry, as a result of which they are prevented to do full-fledged inquiry. This is their affidavit. My lord, I will show later on. My lord, otherwise,
so this was happened, then you came to this court.
Then, my lord, I came to this court.
And
Lordship was kind
remanded the matter to the authority.
Yes, page 50.
The authority have passed this order.
Page 58, my lord, the order, my lord, relegated to the authority. Authority, my lord, started.
58.
Page 58, my lord, the order of the Honorable Reed Court, earlier round.
Yes.
Then, my lord, pursuant to the direction issued by the Honorable Court, first meeting held, that is page 66. My lord, here, my lord, requested me to provide justification to the following question and clarification within 15 days.
Page 68.
66. That I have done. Then, my lord, then page 68, my lord, next order sheet. My lord, at the bottom, lordship will find salient feature made by the Srimati Vidisha Bhattacharya in her online presentation. She has already sent the written representation. She was appointed in the center. There was no appraisal meeting held during 5 years of her service duration. Then, my lord, she was on leave. Next page. When the mail was served by the chairman CFEL for the appraisal meeting, she would not attend the meeting as she was on medical leave. She requested again restoring her job, so and so, my lord. At the bottom, lordship will find the representation made by the Vidisha to be corroborated through official records and applicable rules. This will involve a significant amount of time, attention, and secretarial support. In the meantime, the university will remain closed during so and so time for academic staff member for a fair assessment of representation made by Srimati Vidisha. It is essential to delve into the detailed official record, which can be done only after the vacation period is over. Then, my lord, remain seated, idly, my lord, dealing with this matter. Then I, my lord, filed one application, contempt application before this honorable court. That is page 73. Then final order, my lord. Lordship will find the final order. Before that, contempt order is, my lord, page 89. And 93 is, my lord, the final order passed by them. Here, my lord, very categorically stated, credible evidence and most of the responses are evasive by citing lack of sufficient data or fictitious submission to former authorities. So, my lord, this is stigmatic. This is not a termination simpliciter. Foundation is there, my lord. My lord, that being the situation, thereafter there was a direction for filing, my lord, the affidavit. That I'm reading 1 or 2 paragraphs from their affidavit.
Yes, then what is
Then,
happened?
my lord, their affidavit may kindly be looked into. My lord, affidavit filed by Professor Monoranjan Pradhan. He was at that point of time chairperson, Center for Endangered Language, Vishwabharati. My lord, skipping, my lord, Lordship got it, the affidavit. Yes. Lordship, kindly come to my lord. Paragraph 4, second page. Yes. Before dealing with the contention in the said petition paragraph wise, I say and submit that the petitioner was terminated from the temporary engagement in a project by an order dated so and so as per a terms of engagement. Upon being terminated, the petitioner in her representation prayed for release, my lord, of her salary and issuance of experience certificate without specifically challenging the order of termination. However, the order of termination was challenged by a petitioner at a later stage before this honorable court so and so number, my lord. Then, my lord, in course of such proceeding dated so and so before this honorable court, the petitioner specifically submitted that she prays that she may be offered an opportunity to appear before the review committee and place her case. The petitioner was granted opportunity to make comprehensive representation before the chairperson of the center so and so. The petitioner did not make any prayer and submission for full-fledged inquiry to be conducted prior to her termination. The order dated so and so has not been challenged by the petitioner. Rather, on the contrary, she preferred a contempt proceeding for execution of the same. Therefore, the petitioner is now stopped from making any prayer or submission of full-fledged inquiry. Then, my lord, so my lord, the main issue, my lord, they have ventilated in this affidavit that since I did not ask for any inquiry-related prayer, they are not permitting us. My lord, I have shown, my lord, from our lawyer's letter, we have termed it as a punitive, most unwarranted. The procedure adopted by the university is not the appropriate procedure. My lord, I think, my lord, subject to correction, my lord, this is, my lord, my prayer rather. My lord, I want to show, my lord, the Vishwabharati Act, my lord. Yes. Vishwabharati. Lordship, kindly see, my lord, page 10. Definition, my lord, at the bottom, my lord. 3C. Lordship, got it?
Yes.
Odhapaka includes a professor, reader, lecturer, and any other person engaged in imparting instruction in relation to any learning process and designed as a Odhapak.
So what is your contention? What is the ground for challenging this order?
My lord,
what are the grounds? What are the grounds? You have not set out the ground. What are the grounds?
My lord, the grounds is, my lord, it is stigmatic. It is not termination simpliciter. My lord, full-fledged inquiry is required to be made, and myself is an Odhapak. So far, university rules and regulations are concerned, that to be applicable as per my case is concerned. My lord, this is, my lord, the definition of Odhapako. Then, my lord, lordship, kindly come to, my lord, 3M. Karma Samiti, who will take decision, that is the executive council. Then, my lord, I am drawing lordship attention, section 38A. 38A, my lord, page 36.
Yes.
My lord, the Upacharjo, 38A, my lord, page 36, middle portion, by an order in writing, place an Odhapako or other member of academic staff under suspension, where a disciplinary proceedings against such Odhapako and other members is contemplated or pending, where a case against him or her in respect of criminal offense, so and so. Then, my lord, 38B.
Yes.
No Odhapako and other member of the academic staff appointed by the university shall be dismissed or removed from service or punished in any manner by the authority other than the Karma Samiti, my lord, executive council. Then 2, no Odhapako other member of academic staff appointed by the university shall be dismissed or removed from the service and punished in any other manner except after an inquiry in which he or she has been informed of the charges against him and her and given a reasonable opportunity of being heard in respect of those charges. Then, my lord.
But the problem is that kindly come to the page 41.
41, my lord.
Yes.
Madam, coming.
41 is the first termination notice.
First termination.
Correct. 41 is the first termination notice.
Lordship.
The decision of the review committee held on so and so. Your service has been terminated after 1 month from the issuance of the email dated. So this is your letter. Then you have made the representation.
No, before that, my lord, the court was kind enough to quash it.
Huh?
Court was
So
kind.
that's why, where is that on this?
I am showing, my lord.
Whether this notice was quashed?
I am showing, my lord.
Where is that?
I am showing. Lordship will find.
The notice dated 41 was quashed or not?
Yes, my lord.
Where is that?
I am showing, my lord. I am showing. Lordship, kindly come to page 58. 58, my lord.
Yes.
My lord, 58, my lord, the order runs, my lord. Then, my lord, page 61, bottom, my lord. In view of the above, the instant writ petition is disposed of by granting liberty to the petitioner to make a comprehensive representation before the chairman, Center for Endangered Language, highlighting her grievances. In the event, next page, my lord, such representation is made within a specific period with supporting document. The said representation shall consider the same after giving an opportunity of hearing to the petitioner and pass a reasoned order at the earliest, but positively within a stipulated period of time. Receipt of representation from petitioner, the said respondent shall communicate the reasoned order to the petitioner immediately thereafter.
Yes.
So, my lord, after that, my lord, I may be excused, my lord, I apologize. The particular language quashing is not there,
correct,
but relegated to the appropriate authority.
Correct. That's why
to look into the issue.
That's why the order 41 is only the committee has considered and rejected
Yes.
within 1 month
Yes.
notice. This order has not been caused by this court.
Yes.
Only a given a liberty to give a personal here, give an opportunity to hear a fresh and pass a reason order.
Lordship.
Not the reason order has been passed.
Lordship.
Correct.
Yes.
So you have not taken any stand, but and that's why they have taken the stand in their affidavit in opposition. You have not prayed for any regular inquiry.
No, my lord, initially, my lord.
So once you accepted and this court has given an opportunity of hearing, and opportunity of hearing was given because page 41, you have not appeared and terminated.
Lordship.
Then you have been given an opportunity.
Lordship.
And so what purpose, what further remains here?
No, my lord, the written representation pursuant to the direction issued by this honorable court, I have submitted my representation.
Correct.
That was not gone into.
Why? Where is your representation?
My lord, that is, my lord, I have committed one mistake in
Where
my.
is your representation?
My lord, lying with them also, and my lord, I have committed one mistake. That is, my lord, not enclosed, my lord, with the writ application. Subsequently, seizing the opportunity to file my reply, I have enclosed the entire document. My lord, this is lying with them also.
Where is the?
My lord, I am showing. My reply may kindly be looked into.
Yes.
My lord, the question they have raised, I have answered every question.
Where is your representation?
Lordship, kindly take my reply.
Yes, I am there.
Lordship, page 12.
Yes.
Page 12. My lord, they are considering deficiency in service, my lord. No notice, nothing of this sort. Page 12, my lord. Kindly see question number 1. As per responsibility of your post, this question they have raised. Nature of the job of Center for Endangered Language, Vishwabharati, what have you done to fulfill the center's target during your job for a period of approximately 4 years, 10 months? I have answered. Whether they are satisfied or dissatisfied, nothing recorded. Lordship.
Where is the question?
Question, my lord, the question in the writ application.
No, where you got this question?
No, they have, my lord, sent it at that point of time. I am showing that. That is in the writ application. Lordship will find. These are the question, my lord, raised by them. I am showing, my lord. Lordship, kindly come to page 66. Page 66.
Yes.
Lordship, got page 66, annexure P17.
Correct.
The first question is as per responsibility of your post. Here, Lordship will find the first question in page 12, R1. I have answered. Then, my lord, second question, Lordship will find, my lord.
During the tenure, how many reports?
During your tenure, how many reports you have submitted and obtained certificate from the submission of papers may be submitted. Page 20. This is the second question and thereafter answer. Question number 3. While you were employed, how many field work of linguistic...
With regard to during your tenure, how many reports you have submitted and obtained certificate of submission of papers?
Lordship.
The certificate to give. But who is for the respondents?
My lord.
So you take the page 41. 41 is the original termination.
Yes.
Correct. Now that termination is non-compliance of the page 38. Page 38, you issued the notice to comment appraisal the performance in 4 years. This is the notice. Correct.
Well,
Kindly come to 38.
yes.
So, with reference to terms and conditions, appointment issued to your CFEL project, you are requested to appear before the review committee for appraisal of your performance in the project. This is the only thing which she has to submit. She has not appeared. She has made a representation, given an email to you at page 40. She is in Delhi. She is under medical treatment. So, time may be extended. To be not considered, you are terminated. Not terminated. Now this court has given the her to give representation. How you can access the question, then the page 41, 38. If you go to the access of that 38, then you have to initiate the proceedings. The only one question you have given to her, page 38, to give the appraisal reports. Performance project, what they have done. This is the 38.
Yes.
And she has made a representation to you. She is in Delhi, but you are not considered. You terminated. Page 41. Then this court has given her liberty to make a representation. Once she has made a representation, how you can raise these questions? That is not the terms of termination.
But
That is not the terms of termination.
The order passed by this honorable court.
Give representation and consider. Kindly come to page 68. Not 68.
Page 58 is the...
Yes, page 58. Now kindly come to the page 62. Kindly come to the page 62.
62, yes.
61 start last page. In view of the above, the instant writ petition is disposed of, granting liberty to the petitioner to make comprehensive representation before the chairman. So and so. In the event such representation is made, it has to be considered. So how you can now raise this question? That is not the question of the termination. Now kindly come to 66. How you can supplement? 66.
Yes. Yes, our order, my lord, is at page, my lord, 93.
93. 93 is your order, but how you can supplement? Because your order in continuation of 66.
He did not make a representation.
You have considered the termination, the impugn order.
Question representation for.
Well, this is her representation is at page 12 of the affidavit in reply.
12 of the reply, that is with regard to this reply. Kindly come. Issue now, question number 1, 2, 3.
Yes.
You have raised the issue. How you can raise the issue? That petition is disposed of with regard to the 38. You are only asked to give your report, appraisal report. Only come to the 38.
Yes.
So how you can supplement in the further? If you want to supplement, then the regular inquiry is to be initiated.
He did not submit this.
You have raised this issue, page 66, and she has given the reply, 12A of the reply, affidavit in reply.
Yes.
You satisfied this point. Where is the representation? As per the order of the court.
Well, representation with the reply, my lord.
No, that 12A is with regard to the reply of the 1211. That is their letter.
Yes.
Where is your original representation? When the order was passed?
The order,
High Court order?
24th of August 2021.
24th of August.
My lord,
Correct.
Page 70, my lord, I wrote a letter addressed to my lord the authority. Annexure P20.
This is January 20.
Yes, my lord, that is a notice of contempt.
No, this kindly come to the page 50, 62. 62.
Yes.
This court has given liberty. This court has given liberty to you make representation, and if the representation is made by you, then the authority will consider and pass an order. Where is your representation?
I am coming. My lord, kindly see page 68. They have accepted, my lord. I have sent a written representation. My lord, representation I am not. Page 68, bottom lordship. Salient points made by the Vidisha Bhattacharya. One, she has already sent the written representation. And then, my lord, I am in search of that. My lord.
Proceedings of the yes, submitted representation. Appointed, yes. Also the appraisal meeting. Also yes. So how you this is what is the date of this order sheet? 9th October 2021.
Yes. During Corona.
October 2021. Yes, then 9th October the kindly 68, 69. This is the proceeding you are drawn. After the drawing of how you can write this? You have stated that kindly come to the page 69. The representation has been taken into consideration due to the puja vacation. It will take some time. This is October. Now your November, how you can issue this letter? These are new charges. And this is not the so-called notice. No. High Court order she has submitted. You have taken the kindly come to the 68, 69. You have considered the representation and you stated that you will corroborate the same what she has made the amendments in the representation. You will corroborate the same from the record available in your office. In this order, there is nothing mentioned that yes, clarification will be taken, will be given to the petition. She has to give the clarification. How this 9 point has come? Is the authority can? Because your termination is only with regard to the 38. Consider this. These are the 3 points. 38 is the main termination. Then the court has given representation and representation considered. That is at page 68. So how this, if you are considering this page 66, how it can be? If you are taking all these things, then it is meaning of the inquiry. If it is inquiry, first so cause, then disciplinary inquiry, appointment of inquiry officer, then all the things will come. And if you taken into consideration this is not a punitive order. Huh? Maybe or may not be. That's why I'm asking, if the single order was there, then that can be, that is not a stigma. Page 38 not a stigma. Only opportunity of hearing. But 66 is a stigma. These all the things were not in 38.
Yes, my lord.
You improved that. And you have not taken this point.
My lord, my representation through mail, my lord, page 64.
So consider this.
My lord.
Take instruction. The 66. Note this 4 pages.
Yes, my lord.
Correct. First you take the note of 38.
41 out of
38. Then 41. Then High Court order.
58.
62. Then you are 68. Then 66. How the 66 come? If the 66 you are harping upon 66, then the regular inquiry. As prima facie, you considered it and come at the London Council for the petitioner. Council for the respondents place for time to take instruction. According cases adjourned, let the matter appear. How much time? 1 week?
1 week, my lord.
Let the matter appear on 17th February under the same heading. It is not fixed under the head, urgent motion.
My lord, is it possible, my lord, 19th?
19th?
Yes,
19th February, urgent motion within 5 matters. Within 5 matters.
Good.
Deeply obliged.
It, like, कल के ना कि आज के ओके अगर दोस्त yes, call the matter.
কোথায় এফিডেভিটটা দাও বাবা কোথায়
Item number
এফিডেভিট এত বড় হবে কেন
I appear for the writ petitioners in both the matters.
Because I appear on behalf of the respondent number 5 and the.
There is an order operating restraining the respondents from enforcing the performance bank guarantee.
No,
But
it's
that
not.
is passed in a CAN application filed in the first writ petition. In the first writ petition, there is another CAN, Millard, where Millard, the state of West Bengal had filed a report on the basis of which they say that the goods that I have supplied are inferior. Now, Millard, we have taken out an exception to that said report, which is CAN number 2 in the first writ petition. Now, while CAN number 2 was being heard, Millard, we came to know that they have terminated the contract and hence the second writ petition. Now, Millard, I have taken out an application in the second writ petition that they have filed a report. The report is based on examination of the materials that I have supplied. It is their report coming from them. I have indicated 4 laboratories in India and I have left it to the court to choose any one of them so that those defective goods, Millard, or goods which can be identified them, could be examined and the report of the examination would, Millard, be considered at the time of hearing of the 2 writ petitions. On that, Millard, my learned friends on being filed an objection filed to that. They have not yet filed any objection. And Millard, on the last occasion, it was observed, Millard, that they will come back with instructions as to which one of them they might agree upon. So, Millard, this scan, Millard, or the reliefs in this scan will not decide anything, nor will it prejudicially affect anybody. It is an opinion from an independent person. Your Lordship may even reject it at the final hearing. Your Lordship may not take it at the final hearing, but Millard, this would assist the court in my respectful submission.
So far, my lord, the item number, second item, that is 11. My lord, the related matter. 11. My lord, with regard to that, my lord, supply of hemoglobin testing case, my lord, and my lord, the main issue are almost same. Now, only thing in one matter, my lord, not
Yes, my lord.
terminated at that point of time, the other matter termination, done. With regard to, my lord, they are supplying, my lord. Now, my lord, so far the item number 11 is concerned, pursuant to the direction of this court, my lord, our affidavit is ready. My lord, it's a voluminous affidavit, my lord, we have annexed everything, my lord, for the purpose of, my lord, proper determination of the matter and the issues concerned. Now, my lord, if your lordship, my lord, kindly, my lord, allow us to file this affidavit in, my lord, item number 11, and, my lord, we shall serve it in course of the day. So, my lord, the petitioner counsel. Lordship, kindly allow us, my lord, it is ready, my lord, so 11 is concerned.
In regard to, my lord,
On behalf of the, my lord, affidavit on behalf of the respondents authorities.
Yes, ma'am. In regard to item number 10, my lord, here learned Advocate General is appearing for the respondent, but here, my lord, this matter placed before your lordship today, first time. There is no such direction of filing of report, and my lord, we are not filing any report here. So, my lord, kindly, no, my lord, kindly see, my lord, my petition number is 26421. Here, 14th January, matter was taken up by your lordships and adjournment was given. There's no such direction to file a report, or, my lord, we did not file anything in this matter. So, my lord, a direction may be given, my lord.
Yes, your lordship.
Here, my lord, I challenge, here, my lord, the writ petitioner challenged the order of termination only.
Your lordships, I appear on behalf of the respondent number 5 in 26421. I supplement what my senior has said, that we must be allowed to file our replies and affidavits, and then thereafter a decision may be taken on the CAN 1.
Yes. So, Mr. Sen, you have filed the affidavit in opposition WP or CAN?
My lord, the WP.
WP, not the CAN.
It's a private response.
What about the CAN?
My lord, the CAN, my lord, I have not myself. My lord, the department, it is with the department.
No, the CAN is only with regard to appoint any of the authority. 4 M's name has been given. To whom it,
Secondary CAN bache. First kichu hai.
to whom it is to be sent. All are the aims. It is not asking for any private further.
Your lordships may appreciate the fact that
Item number 10, there are private party, my lord.
yes,
Here, my lord, probably.
Point number 5.
If the, my lord, if it appears, your lordship, that the pleadings are otherwise ready with regard to the main matter, then lordship must offer, my lord, the respondent concerned, they have filed their opposition, they have to file their reply if they so choose. Then, my lord, the main writ petition can be taken.
That's correct. But what is
the so far the CAN, what I have heard, I have gone through, my lord, in any CAN filed in the second matter, there is item regarding subsidization. Now, my lord, if it appears before the court that the matter is otherwise ready, I leave it to your lordship.
What is the CAN in the first matter? This
second matter.
This matter 15978.
CAN number 1 in the first writ petition, my lord, is seeking an order restraining them from enforcing the bank guarantee. My lord, I have a bunch of orders, my lord, passed in both the CANs, my lord. If your lordship produces this, my lord.
CAN number 1.
My lord, your lordship, it's not stitched in a manner I don't know how that it's from bottom to top. Then lordship, my lord, kindly staple it. Staple staple. I'm sorry, my lord, I ought to have stitched it for the. Your lordship has the first order, 1st of August 2025.
Final report especially disclosing a number of strips and the meters that have been used. The report shall disclose the number. So, this is 1st August 2025.
This is the report, my lord, which I was referring to, my lord. My learned friend.
No report is filed.
That report is there.
No, report filed.
They had filed a report. We have taken an exception to that.
No, my lord, my rate is different. 26421.
Not to make confusion, 15978 you are not there. That's I am on.
I'm also not there, Your Lordship, in 15926.
You are there.
I'm also in 26421
Then
only.
I will come to the other.
Yes.
So 15. So first order is for filing the report. They file the report. You file the exception. Now the second.
17th of September, Millard, report submitted by a copy of the same has been served. Open to the petitioners to file exception to the report. Release the matter on 7th of November. Second order. Third order is 24th of August, September 2025.
Obtain proper
interlocutory application has been filed. This is CAN 1. Instance of the petitioner seeking a restraint order on the respondent from invoking the performance bank guarantee to enable the learned counsel of the state to obtain for the matter hearing adjourned today, reduce the matter, all the parties are to act for summons copy. Then the last order is 25th of September 2025 in CAN 1. It appears that the contract of the petition has been terminated and the legality of the same is to be adjudicated by the court in writ proceedings.
So restraining.
A restraining order. This is so far as
So
CAN
28 number.
Yes.
So this is CAN number 1 is with
CAN
regard
number
to the
1
interim
and Millard, CAN number 2 is Millard. I was given liberty to file an exception to that report. That is CAN number 2.
Okay.
So this is so far as the first writ petition is concerned. Now in
So
the
in
first
first petition, the interim order is continuing
yes,
till today.
Till 9th of February.
9th of February. Yes. Then
This is so far. Terminated in the first writ petition, when we filed, there was no termination. Termination has come subsequently. So we filed the second writ petition. And this application CAN number 1 in the second writ petition, Millard, is to choose any one of those experts, Millard, the court so feels, for the purpose of giving a report.
So-
This is, Millard, the status of the
so
two.
appointment of the expert is in WP 26421.
Yes.
Yes.
26421 here, my lord.
4621 you are appearing for the
Yes,
authorities.
But no CAN 2 served upon us.
CAN
Lord.
2 is not there.
No, only
Only
writ
one
petition.
CAN.
My lord, only writ petition.
No, CAN 1.
No, my lord. There is no CAN 1. CAN 1 in
But there is a CAN 1 filed by.
CAN 1 says, my lord, it should be 19 something.
No. 19 something.
My lord, CAN 1 and 2 filed in 15978.
And other is
There is another CAN 1 filed in
Petition where
26421.
termination order has been challenged. There, my lord, no further application has been filed. And this is the first time, my lord, I am appearing before your lordship with this matter.
CAN is there.
CAN is
For
there.
the last 3
Evidence,
dates
sir.
he is mentioning, Mr. CAN 1 is there and last 3 dates he is mentioning the same. You
Yes.
had appeared. The other parties have also appeared.
not appearing, Millard.
What you are telling, madam?
No, my lord, my
Yes, I see I might be I am not knowledgeable, but my IQ is my IQ is so much. Who has appeared, who will not appear, I can understand.
There seems to be some confusion, my lords.
My lord, I probably I have. No, my lord, then
Who has taken? Yes, we'll take the instruction. To whom it has been taken. That's why on 2nd February also it was mentioned. On 2nd February also it was mentioned, and you have taken time, and this court has fixed today because of the first matter is fixed today.
Thrice, Millard, this matter was adjourned on their ground that they will come back with the instructions as to which one they want.
Your Lordship, if I may suggest a last opportunity.
So far,
to
yes.
take.
So far as the respondent number 5 is concerned, Millard, my learned friend is making submissions from. But Millard, we have found out that they have not yet entered appearance through Wakalatnama.
Yes, Your Lordship, I will file my Wakalatnama and.
Then how did he make submissions on the 3 days without submitting before the court that I have not filed a Wakalatnama?
No, Your Lordships, I will file.
And the court took
I will
cognizance
file.
of his submissions without
The-
proper.
I will be filing my Wakalatnama.
So he should have brought it on the notice of the court the very first day when he sought an adjournment and opposed my prayer.
No, I didn't seek any adjournment. I will be filing my Wakalatnama during the course of.
What is your stand in the CAN 1 of the regarded
This
petition?
can be my lord served upon us.
So
My lord, I
definitely,
asked my advocate on record that no copy has been served according to Shoman Chatterjee.
Millard, may I say this, Millard?
Affidavit of service is there.
Yes.
I think there is some miscommunication in our matter, my lord.
You do one thing.
Can be solved upon.
You give one copy,
It is
Mr. Datto.
copy, my lord.
You give one copy to her.
Yes, that is the better. Copy
And my lord, direction may be given, my lord, us to file a report within short.
report aage hoyni.
না আমি তো তাই বলছি আমি এখন জানি না
Lord, kindly appreciate me, Lord. I have supplied to them in 3 tranches 36 lakh strips and 17 lakh machines over a period on 3 tranches. The contract says that upon receipt of these goods, they will inspect and certify that the goods are in order. All the 3 tranches have this certificate of incorporation issued by the respondents themselves. So far as this writ petition is concerned, I can boldly say, Millard, it's certified by them. But Millard, after all, these are machines. Mere certification, when it goes to trial, there can be. It's a bulk supply. So Millard, that's why, Millard, I am not insisting on that. But Millard, the moment I ask for payment, and I have supplied them this entire commodity without even receiving even 1 paisa. Till date, I have not received 1 paisa. And when they cancel, they don't say that 5 of your 63 lakhs are bad. They said change the entire 63 lakhs. When I say that, very well indicate which machines are bad. They say you take back or replace the entire thing. Now, Millard, in these circumstances, my client is also a commercial. He's come to do business in this state. I am not asking for anything. This Can 1 will not prejudice anybody. Millard, without prejudice to the rights, your lordship can also observe that the report may come and it is without prejudice to the rights and obligations of the respondents. Even to that extent, Millard, I can go.
Okay. Yes.
Well, instead of report, if your lordship allow me to file affidavit in opposition this matter, comprehensive affidavit in opposition. Deal, my lord, later, my lord, 2 weeks, my lord, be given as.
And main matter, let them come with a comprehensive short affidavit. They might not be intimating the stand, because in almost similar matter, the respondent already might not intimated their stand in the affidavit that I have filed before your lordship.
See that, okay, you file the affidavit with regard to the calling for the report from another authority, that can
without prejudice to the rights and contentions.
If you object also, okay, I taken your object. Correct. If at the time of hearing of the case, if this court found that yes, some expert report is required, what will happen?
My lord, here, my lord, basically, if your lordship allow me to, my lord, bring on some record.
What?
Record is report from AIMS. My lord, report from Nil Ratan Hospital, report from our, my lord.
That is on the basis of
my
that
lord,
you have
here, my lord, this second writ petition means, my lord, item number 10 has been challenged, specifically challenging the order of termination.
Correct.
So, my lord,
what is the ground of what is the ground of termination?
Ground of termination is not, my lord, not as a, my lord, bring their 2 things they supplied, 1 meter, another strip. My lord, we send each and every meter and string to the authorities, means, my lord, the Nil Ratan Hospital, Medical College and AIMS. My lord, it cannot, none of this meter, none of the strip, my lord, reach to the specification made in the notice inviting tender.
So how you accepted?
Specification, my lord, certain.
How you accepted?
My lord?
How you accepted that?
My lord, at the time of my lord providing this meter and my lord strip, my lord, that point of time, my lord, they are not going through all this scrutiny, my lord. When we got, my lord, complaint from the Dokhin Dinajpur, then we found that certain time one person, his in this glucometer, my lord, it found that the sugar level is 0 and sometimes 34. My lord, this is, my lord, kindly allow me to place entire document. I don't think, my lord, the report filed in the previous writ petitions, means, my lord, the writ petition of our learned advocate, additional advocate general, my lord, I don't think this document has been placed before your lordship.
Of course.
My lord, allow me to do this.
Millard, kindly take 1 page at page 91 of the first writ petition.
with WP 2647.
Yes, my lord.
And my lord, this termination order passed long back.
Page number?
Page 91, your lordship takes. This is in terms of the contract.
Yes.
My lord, this is certificate in respect of these certificates were issued in respect of the entire commodity that are
91.
91. It is a satisfactory installation of the first writ petition.
First writ petition, which that WP number?
My lord,
No, 1597. You're
তো confused করেন কেন?
91.
Page 91.
Yes.
Your lordship has a satisfactory installation certificate.
Yes.
This is issued in respect of all the commodities that I have supplied. This is to certify that the equipment as detailed below has been received in good condition along with all standards and specific accessories, consumables, set of spares in accordance with the contract equipment and site preparation including interiors as per bid document. The supplier has submitted the following: tools for maintenance, detailed operation of maintenance manual in hard and soft copy of it. The proving test has been done to our entire satisfaction. The equipments, its accessories and ancillaries of the site preparation, including interiors and subscription, are satisfactory and faultless. The following operators and users have been trained to operate the equipment. This certificate covers the consignment, and the contract says that it is only upon receipt of this certificate that I am entitled to payment. When I ask for payment, then all these things come.
Yes. Okay, let's see.
Not ma.
The WP number 15978 with CAN 1 of 2025 with CAN 2 of 2025. The respondent number, all respondents.
My lord, I'm appearing for the
Mrs. Sen, Mrs. Sen.
Yes.
All respondents.
Yes.
The respondent authorities have filed the affidavit in opposition after serving the copy to the land council for the petitioner. Let the same be kept with the record. The petitioner is liberty to file reply by.
खूप मोठा लिहिलं
मोठा আছে
annexes 2 weeks. 2 weeks.
Within 2 weeks, a reply if any there to be filed, and within 2 weeks, full stop. In this, there is no interim order.
No, in this there is no.
Within 2 weeks. ठीक है अब दूसरा WPA 26421 of 2025 with CAN 1 of 2025.
Copy also
Recorded. The counsel for the state authorities press for time to file affidavit in opposition. Let affidavit in opposition be filed by 2 weeks.
My lord.
2 weeks. Reply by 2 weeks.
To CAN 1 of
No, WPA.
let them file opposition. I'll file a combined reply in both.
Yes, my lord.
The counsel for the state authority press for time to file affidavit in opposition with respect to the WPA 26421 as well as CAN 1 of 2025. Let affidavit in opposition be filed within 2 weeks. Reply if any there to be filed within 2 weeks thereafter. Full stop.
But the liberty to respond number 5 also.
Let both. You are not filing wakalatnama. I am not hearing you.
9th below the interim order is expiring.
Let both the matter be appear. 4 weeks हो गया ना? आज कितना तारीख है? 6 तारीख, 5 तारीख.
मार्च.
कोई डेट है? देखो फिक्सिंग हियरिंग के लिए मार्च में. 2 डेट दे दो दोनों. 17th and 18th March. 17th and 18th March at 12 noon. For hearing, interim order is extended. Interim order in WPA number 26421 of 2025 is extended.
The first one, interim order in first one, 987. 1597.
Interim order is extended in the is extended till 20th March 2026 or until further notice?
Milord, I may be filing my wakalatnama, please.
File wakalatnama, then come.
Yes, I'll file my reply and the wakalatnama.
Yes.
In the second writ petition, this can for appointing somebody, Milord. The Lordship pass an order observing without prejudice to the right.
Let the file affidavit. What can be done? They want the affidavit.
Yes.
That must be why,
Milord, I will file my wakalatnama and my reply.
Why? It's not apprehensive.
Why not apprehensive?
my lord, regarding maintainability of the writ petition.
You mind it? I will not allow you to file affidavit in opposition. Future 3 dates you are appearing. You are not filing a wakalatnama. I am not
apologize,
allowing you.
Your Lordship.
And
I will.
on that day, you will ask for the affidavit. I will not grant the time to you.
No, I will file my wakalatnama as well as the reply.
Yes, next.
Thank you, Lordship.
सब देख के रखना.
Appearance also training. And number 13.
Now, this is the matter, my lord. Your lordship will remember that I am appealing for the school, Chinese school. The government of West Bengal has requested us for giving the school premises for 2 months.
Yes.
We have said we can give only 2 months, but they are still not vacated. My lord, we could have performed the Chinese New Year in 2004, 24, in 25, now 26. It is on 14.
Yes. What is the report, sir?
One question, my lord.
Let me.
My lord, report in the form of affidavit already filed, my lord, matter on the earlier occasions. My lord, in the report we have stated that in view of the fact that the Honorable Supreme Court said that the nearest location should be found out. My lord, for the purpose of my lord, they are, my lord, the residents of the temporary residents of the my lord CISF personnel who will be at that point of time. Now, the Supreme Court matter already, my lord, the Supreme Court demanded back the High Court Supreme Court. Now, my lord, we have stated in our very short report that yes, the nearest location, my lord, we could not find out any other, but that the school was not functioning. We approached them and they, my lord, also accepted, my lord, our request. And yes, my lord, initially it was 2 months. Now, my lord, we have also seen in our affidavit that we have, my lord, paid almost about 50 lakh rupees
Without our consent. It's a crime.
It's a খুব দরকার না 50 lakhs rupees.
It's a crime. Without the consent of the owner, you cannot pay it.
দেখুন চেঁচাবেন না কোর্টে
Another matter.
Yes.
Well, I'm sorry, but
This way,
let the matter appear. Let the
will
record an order.
Okay. I don't.
The matter was taken up for hearing, but this court found that the petition, the counsel for the petitioner is not the counsel for the petitioner is not allowing the learned advocate appearing for the estate and disturbing the proceeding. Accordingly, this court is not in position to take the matter. Let the matter appear in the combined monthly list of 2026.
Give the grievance of the people of the Chinese community, my lord.
When I have taken the determination of this court for the 3 dates, I already stated I will not bear any submission of the advocate overlapping the submission of the other.
Okay, my lord, I can't.
Sorry.
Unconditional apology, my lord.
No.
Because of me, the petitioner cannot be suffered.
Juniors will run the same thing. That's why I will not.
I have practiced for
call the
27
next
years,
matter.
my lord. Please take my apology.
It is April 2026.
My lord will see the pain, my lord. I don't shout in normal
Yes,
cases, but I'm 27 years practicing. My lord, please give me. I'm holding my hand, my lord. Unconditional apology, man. When I'm holding my hand,
This type I am not. This court
my mouth.
Maybe not now. Now matter is over. I dictated. That's all.
My lord will not punish the petitioner.
Sir,
my lord.
please. Yes, call the matter.
But I've folded my hands and asked for apology, my lord.
Twice I have instructed not to. Again.
I bow down to
No. You go and take
my
it.
lord, please, my lord.
Please, sir. Otherwise, I will not send further order anything. Then it will be difficult for your career.
Punish this.
Yes, call the.
All children of the Chinese community. My lord.
Lordship should know how the advocate is to be engaged. Which type of the advocate is to be engaged.
Well, I bow down to a lordship.
Sorry.
I'm taking unconditional apology.
Call the matter.
But in this
Lordship, I am for the
Appears on behalf of the petition. So you mentioned why you are standing there. His habit is like that only.
Lordship, I am led by learned ASCI.
Sorry, sir. Please, you go. Please, you go from here. Go behind and sit in behind. I will not hear you.
Lordship, I am led by learned ASCI. I am seeking for a short passover. He is appearing before court number 1.
Last date's order. When they were taken time to reply or
Yes, on the last occasion you taken time 9 January.
yeah.
Then the matter is.
Lordship, kindly give a short passover.
What short passover? Yes.
I'm appearing for the statement.
My submission has been over, and your lordship heard me at length, and after hearing this, your lordship is to direct my learned friend to reply to the same. Lord, I have prepared a list of dates for my understanding. Can I hand it over to my lord, to assist my lord? I have copy দিয়ে দাও বলুন।
Yes.
নারায়ণগিরি কোথায়? নারায়ণগিরি না? কিছুক্ষণ চলবে।
What is the most vital point? When the sanction of the pension was done in favor of my father, when she was not at all in this term. Before, after death, pension was sanctioned to the father. That have come to the knowledge of the government. Family pension was granted to my mother in 1989. She died and got the pension till 21. I am asking myself as to how the sanction of pension against my father can be revoked or cancelled in 25 or 26. This is the moot question. After a long lapse of 30 or 35 years,
Let me hear ASG.
We took the preliminary point that we are authorized under the scheme to reopen any matter if pension has been obtained by fraud or misrepresentation. Kindly come to page 67. That is the exact submission I made on the last occasion. Kindly come to page 67.
Yes.
Of his own writ petition.
Yes.
This is, my lord, a notice to show cause to Ashutosh Maiti, the erstwhile pension holder.
Yes.
Now, this is, I am directed to refer court order number such and such, passed by the Honorable Supreme Court of India in SLP number such and such, title such and others, along with clubbed SLPs and such, whereby the Honorable Supreme Court of India has passed the following directions. Learned counsel appearing for the respondents points out that some of the legal representations of the deceased respondents have not been brought on record. He may furnish the details of such persons to the learned advocate on record for the petitioners, who in turn may take necessary steps to bring the said parties on record. Next, Ms. Madhavi Diwan, learned Additional Solicitor General on instruction, submits that inquiry has been more or less completed after the inspection of records which had become available to the committee. They have scanned almost 20,000 files and have found that around 2,229 certificates were issued by one individual, which is the issue of consideration in these proceedings. Then kindly come next page. As we are required to refer the hearing of these matters to enable the petitioners to bring on record the remaining heirs and legal representatives of the deceased correspondents, we make it clear that pendency of these matters will not come in the way of the authorities to proceed in the concerned matter in accordance with law
if the fact situation so warrants, including to cancel the certificates after following due process and take appropriate action against the erring efficient officials, persons involved in issuance of such fraudulent certificates. And list these matters. Now kindly come to next para 2. In view of the above direction, all the cases have been reviewed and it has been tentatively proposed to cancel the freedom fighter pension, dependent pension, wherein the personal knowledge certificates had been issued by Sri R.N. Giri indiscriminately. Your case has also one of the cases where PKC has been issued by R.N. Giri. Hence, as per directions of the Apex Court referred above, you are hereby called upon to submit either in person or in writing your explanation and defense in respect to the authenticity of PKC issued by Sri R.N. Giri, which is being considered to be issued indiscriminately within 1 month and such. These are the directions. Now kindly come to next one. Where is the answer to the authority except that page 70? Kajal Mahdi have received your letter dated 15 July 2022, possibly this one. Yeah, no, it is not that. Another one. And freedom fighter in 1982, he applied for freedom fighter pension after proper verification. It was granted. After my father's death, my mother Joshoda Maiti received pension. This is the answer. And then, may not kindly, this is postal receipts. All this, I don't find any such answer or so-called answer to the Deputy Secretary or the Joint Secretary, Freedom Fighters Pension Home Department, except that an order which is again, may not kindly come to page 74. This is another letter written on 13th February 2023 to Ashutosh Maiti. This is Learned Counsel appearing for the respondent points out that some of the legal representatives of the deceased respondents have not been brought on record. He may furnish the details of such persons to the learned advocate on record for the petitioner, who in turn may take necessary steps to bring the said parties on record. Madhavi, the one, this is the reference to earlier one. Kindly come to last part, the para 6, that keeping in view of the above mentioned facts and in light of the court order dated 27 April 22 and on 1st November 22 passed by the Honorable Supreme Court of India, claim agitation of concerned claimants have hereby cancelled, and further the suspension sanctioned by this ministry on the claim application submitted on the basis of PKC of R.N. Giri is also stand cancelled. If it is cancelled, therefore, this has to be challenged and it shall be proved beyond reasonable doubt that the personal knowledge certificate is genuine. Another point cannot be argued before your lordship. And issue is still pending before the Supreme Court. Now, in one of the appeals, where my learned friend also appeared, Sukhdev Maiti's case, the division bench presided by the Honorable Chief Justice directed to hold an inquiry and come to a finding about report. That appeal also relating to R.N. Giri's certificate that is pending before the division bench for final adjudication. So kindly keep it pending. Let that division bench matter be decided first. This is, my lord, MAT number 1132 of 2023, Union of India, our appeal.
MAT number?
MAT number 1132 of 2023, Union of India, others versus Sukhdev Maiti and others. The same issue.
Yes.
Let that matter be decided. Let that division bench come to a finding that the certificate indiscriminately issued by R.N. Giri was genuine. Then he has a jurisdiction to come before your lordship and argue on this. Okay. He cannot argue on any other merit now.
Yes, Mr. Manu.
My learned friend has first raised the point that Mr. Giri has issued numbers of certificate indiscriminately. Has it, I'm asking myself, has it been proved or decided by any of the court?
So that's why when the matter is pending.
What I am firstly, I am on the point of the first show-cause notice. My lord, your lordship can have a look to the show-cause notice dated at page 67.
Yes, 67 of
it has been addressed to my deceased father,
correct,
who died in 1984.
Correct.
And show-cause is 22.
Correct.
But can it sustain in law? I am asking myself.
No, whatever.
That too. Pension was not given to him. Pension was subsequently sanctioned firstly in favor of my mother in the year 1987. 87 or 89. It may be 89, my lord. She enjoyed the pension till 21. But I am asking myself, after the death of a person, about 25 years later or 30 years later, can anything be passed against him? But even if a person has committed a wrong, can he be punished after his death of 30 years? I'm asking this myself.
No, it is,
That too.
it is, Mr.
That too,
Mr.
that
Manna,
my learned
it
friend.
is not with regard to the punishment. Rightly and wrongly, whatever it is, the wife has got the pension. Correct. Rightly or wrongly, your wife has got the pension. Now, wife died. Now, the daughter has applied for continuation of the same. Now the matter is, this can be continued or not, because the certificate issued by Mr. Giri is the subject matter of the division bench of the honorable division bench of this court. Okay. If it is found that this, if the certificates issued by Mr. Giri is not in accordance with law or fraud or fraudulent, whatever it is, so automatically you will not be entitled to get it. So once let the division bench conclude the proceeding, because it is not.
I have perfectly understood.
It is not the case of the authorities. Not whatever the amount received by wife is to be revert back. What it is not the case. Now your case is to be considered in continuation of the wife entitlement.
I am asking myself, as to my learned friend's client, can treat that discriminately to others when R&D certificate is in question
Correct.
before the Supreme Court.
Correct. That cannot be discriminatory, because your wife got it. You cannot say it is a discriminatory. Your wife has got it. Now your daughter has applied for. Now this question has been raised by the authority. This question has to be decided once, either this way or that way.
As per the scheme, on the death of my mother, I am entitled, subject to satisfy the two condition. I have satisfied.
Correct.
They have taken the point that certificate of Mr. Giri is
When the mother died,
21.
21. Then the notice was of 2022.
Then against my father.
Maybe
replied to
because the
them.
ministry can't say whether the Asutosh Mehta is alive or not. Once the ministry has came to know about all the things, who is getting the pension with regard to the certificate issued by the RN Giri, the ministry had issued the notices. Now,
No, Lord.
why this notice has come?
Notice to my father, who was never got.
Not God, but the pensioner is, man. The name is the who is the freedom fighter?
My father.
Then the name of your father is in the bits of the ministry, not the daughter, not the wife.
No.
Correct. So what was the name before the ministry? They have issued the notice. Ministry has no knowledge whether the mate is alive, your wife is alive, or the daughter is alive.
That is the question I am raising. It is their case that when it revealed to them that my father died before sanctioning the pension, gave sanctioned pension in favor of my mother. That is my case. So
once
against
you
my
cannot
father,
say, Mr.
against my
Manna.
mother, no show cause was ever issued. I have replied to the show cause against my dead father. That too, the centering the certificate of Mr. Giri, as my learned friend has pointed out, because thereafter, after the order as referred in this writ application, they have at least granted pension to 3 or 4 persons in whose favor Mr. Giri's certificate is there. I got I have
when it was granted.
That has been granted in 25 even. I have given the number. Just my lord, Lord, if your lordship kindly take the case of Lord Purnima Bhuya. He is my client. His father did not get the pension. Mother was allowed to get the pension. Mother died. Then in the become Rasmoni Shao also they got the pension. আরে ভাই আমি আসি দাঁড়াও বলতে দাও না why you are disturbing please let me submit লাইনে রেজ দি বলছি আবার তুমি কেন বলছো
how can you raise issues which are not part of litigation?
No, I am raising that list question. সেটা জজের কিন্তু রিপ্লাই তো বলো আমাকে কেন বলছো ভাই the same person in the case of the Purnima Hoya, Rasmoni Shao I have mirror page 99 in 99 in our 99. Rasmani sir to দেওয়া আছে in Purva Bhuya, Rasmani Shau, and even in the case of Miller, they were aware.
Correct. That
Which
was
Miller went up to the Supreme Court.
correct. That was given by the authority because of the order passed by the single bench, which was upheld by the division bench, and they are not complied with, and the contempt application was moved.
In this case,
Yes. Kindly come to the page 23. Come to page 23 of
yes, 23 of the order.
Yes. Kindly come to the page 23.
That to Miller, I am coming also. The pendency of the application cannot be taken into account. I like to refer. 23, your lordship can have a look. I am directed.
Read the subject. Implementation of the order. Read the subject.
Read the date of the order is 12th of March 2025.
Subject.
The implementation of the order dated 14th of February 25.
Correct.
Passed by the Honorable Court at WPCT number such and such.
Correct.
Filed by Srimati Rasmani Shau, widow daughter of such and such. And widow such and such. I am directed to refer the judgment dated 14th of February 1925, passed by the Honorable High Court at Calcutta in WPCRC 303 of 2019, in WP number such and such, wherein the alleged contemner are directed to sanction the freedom fighters pension in favor of the petitioner, not from the date of the order, that is 15th April 24.
That's why I am telling, why I have told you to read this, why I have requested you to read this, because this order was passed at that time. This point was not raised before the court, and the court has passed an order, and in WPCPC, because the authority had no other alternative but to comply with the order. Now the authorities have raised the issue with regard to, then the document is produced. Once there is a genuinity of the document is questioned, can at this stage let for the time being, let the matter be sine die, for the time being.
If that point be exists till then, but the Honorable Supreme Court is not on that point now. They have challenged, but I am showing that not allowed. And that to me, I am referring another judgment also. But this point was taken that as the point is sitting of the Honorable Supreme Court, so kindly don't pass any order before this court as well as before the Delhi High Court. In Delhi High Court, in the case of, Srimati Koli Indira, but wherein it has been found that the pendency of the case cannot be taken into account.
No, these are not part of the court. I am seriously objecting.
No.
No. He has to file a supplementary affidavit. We shall reply to that. Secondly, our constitution does not recognize negative equality.
No, that's correct. That's why. No, he's relying.
No, these are not part of the court.
No, he's relying upon the judgment. It's a judgment. It's a judgment. He's relying upon the judgment, not the document.
I really feel sorry when my learned friend is first learned advocate, and that too in the SG of the court. I being a petty lawyer, how he can show the finger to me? It's really
I'm not showing finger to you.
No, not that. Not to take that.
No, I don't like to raise any objection. Your lordship is there. Your lordship can have a look. It's a contradict calling there. But calling there. Sorry, my lord, I'm sorry, my lord, I have raised my voice. My lord, sorry, my lord, I may be excused. My lord, paragraph, my lord, your lordship can see that as regards to page 37. এটা ব্যাগে দেখি আমি কি করে দেবো এটা প্যারাগ্রাফ এটা খাইটা দাও না কোন প্যারাটা বলো as regards the contents of that the judicial decision
paragraph
প্যারাগ্রাফটা বলো ওখানে লেখা আছে will answer. But just a minute. Will. এটা না page I'm just 37 my lord, it is the my lord is the paragraph 11 at page 9 of 11, my lord, last paragraph. At page 9 of the judgment, the last paragraph, it starts as regards the contention. But it has marked the paragraph on the previous case, 11. Then, my lord, your lordship, kindly skip over to the next page. It starts as regards the contention. Then, there are fifth line from the last. Since mere pendency of challenge in a different case cannot have any direct bearing on the adjudication at hand. It has been held by the division bench of Delhi High Court. In our High Court also, in the case of, you know, when I am referring the judgment, in the case of Sonali Hatwagiri, okay. In the case of Sonali Hatwagiri, Miller, I am referring page number 7 of the judgment. Well, I am giving the reference WPA number 13806 of 2019. Well, page number 7. Well, judgment page number 7.
Yes.
Second paragraph starts.
Yes.
As regards the here also this contention was raised. The RNGD certificate has been challenged before the Supreme Court, those are pending. As regards contention of respondent number 1, that judicial decorum ought to constrain the hands of this court due to pendency of a similar issue before the Supreme Court. Such contention is not acceptable, at least in the present case, since mere pendency of a challenge in a different case cannot have any direct bearing on the application adjudication at hand. Number 2, my learned friend has said that the certificate is in challenge before the Supreme Court. Fact, initially this point was raised. When the government of India was directed to give the report, they have given the report, wherein they have stated only 167 persons, certificate to 167 persons was given by Mr. Giri. Then they have not pressing the point of indiscriminate issuance certificate by RN Giri. As a result thereof, in subsequent judgment, what the Honorable Supreme Court has said, I am referring that judgment. Now, order our file now. কোথায় যাই ওই ফাইলটা কোথায় অর্ডারের ফাইলটা দুটো ফাইল আছে দেখো ওখানে ভিতরে ফাইলটা এইদিকে দাও আই এম সরি মিলর্ড আরো একটা ফাইল আছে দাও একটা করে দাও Your Lordship, kindly have a look to. Your Lordship, kindly ignore me. Ignore the marking of my page number. 82. 82. Subsequent order. Judgment কোথায়? কোর্টের অর্ডার সুপ্রিম কোর্টের। যে মামলাটা বলছেন টোটালি কোর্ট আছে। It is the order of the Supreme Court dated 24th of July 2024. But I am referring page number 82. It is seen that various clauses of the scheme and amendments made time to time are under consideration. For that reason, I am asking myself as to whether there is the question of consideration of the certificate. As my learned friend has referred. After filing the report, that point has gone. They are not pressing that point. তারপরে আরেকটা order আছে দেখো। Unreported order কেন? Reported order, রামপদ বাজার।
What you want to say from this order? Page 82, this order?
82, they are the issuance of certificate by Arangiri is not in dispute or is not in the decision of the Supreme Court. Here the Supreme Court is hearing the various paras or sections of the scheme and amendment thereto. Interpretation of the statute, not the certificate of Mr. Giri, because they have found only 167 certificate has been issued by Mr. Giri. Out of the applicant from West Bengal, 36,000. There were 36,000 applications in Bengal, in Midnapur. For Bengal, it was only 70,000. Out of 70,000, Midnapur is 36,000 applicants. Out of 37,000, 2,200 and odd certificates are found by issued by the Arangiri.
No, then you come to the page 75. Come to the page 75 of the writ application.
Page 75
of the writ application. Writ petition.
75. Yes, ma'am.
Correct. This was addressed to you. This was addressed to you or your husband. Now kindly come to the page 6, page 75, paragraph 6.
Paragraph 6.
Yes. Did the...
I am asking this here. I am here. Who has decided that certificate is not genuine? Has my learned friend has already decided, or any court has decided? I am on that point. The Honorable Supreme Court on earlier decision taken state this order will not prevent on the way to take.
No, that's why kindly come to the paragraph 6. Whether this was addressed to you, and paragraph 6 issued by the R.N. Giri in favor of so and so application or concern are hereby cancelled. Whether with regard to the certificate which has been issued to the Ashutosh has also been cancelled or not?
They are saying that cancelled in 22.
There is no document to show that how they have cancelled.
They are saying they have cancelled.
What is the proceeding?
On the basis of the notice, as I have shown to my lord.
That's why, see.
In 22.
What the judgments you are relying upon, that is the settled position. Okay, what the case is pending with regard to the other, that is no problem at all.
Yes.
Now kindly come to the page 75. And it was specifically informed to you.
Yes.
And paragraph 6 are categorically stated that the PKC is issued by R.N. Giri in favor of SSS pension claim application of the concerned claimants are hereby cancelled. So whether you are also, your certificate is also cancelled or not?
I could not follow. My father's certificate has been cancelled.
Then
who has died long before 40 years?
Your father's certificate, based upon the same certificate, your wife has claimed.
Yes.
And based upon that, the now daughter is claiming. But once that has been cancelled, how you can continue?
Why they have cancelled? They have cancelled that Mr. Giri issued certificate indiscriminately.
Correct.
So this is not the genuine. Is there? I am asking myself: is there any finding of the government of India or by any court, save and accept a mere statement by a single bench, which has been overruled by the division bench, and they have complied with the division bench order by paying the pension?
No, single bench, whether this point was raised. This point was raised, whether the certificate was cancelled and that was not.
Yes, that was the second.
Where is that finding in the single bench order?
The R.N. Giri certificate was first in Milord raised doubt about the certificate by one of the single bench of this honorable court in 3 matters heard analogously. Because I have not annexed. Because I have not annexed. But I will refer. I got that judgment also. Because in that matter, the honorable
Just a minute, Mr. Chakravarti, this the memorandum which you mentioned relied upon, page 75 of the writ petition, paragraph 6. Page 75, paragraph 6 of the writ petition.
Yes.
So this whether
Paragraph 6.
Paragraph 6, page 75. Last 3 lines. Issued by Sri R.N. Giri in favor of SSS pension claim, application of concerned claimants are hereby cancelled. So whether this cancellation includes the petitioner certificate?
This is written to
the Asutosh Mehti. That is the husband.
Then again, kindly come next one. He moved a writ petition before this honorable court. That is at page 76.
Yes.
Now, what is the direction in the writ court? These things he is annexing the Supreme Court order, appointing inquiry about R.N. certificates, but what he is submitting he has not annexed. So these are matters to be decided on affidavit. Secondly, the writ petition which was disposed of, it would be premature to decide on the ultimate conclusion which may be taken by the respondent authorities. Kindly come to page 78. Accordingly, para 6, WPA number is disposed of by directing the respondent authorities to give a reasoned order on the representation of the petitioner and communicate the same. This is written directly to Kajol Maiti, present petitioner.
Correct.
The same to the petitioner, preferably within 5 weeks from date.
Yes.
It is made clear that in the event the petitioner is aggrieved by this outcome of such consideration, it will be open to the petitioner to challenge the same before this court appraise.
Yes.
Now, what is the decision taken? Kindly come next paragraph, next page. This is a detailed reasoned order passed by the Deputy Secretary Home.
The case of Asutosh Mehti has been examined in view of the judgment of Kolkata.
Yes, kindly come to
page that
page
was
8.
granted as solely on the basis of PKC R.N. Giri.
Yes, this has been communicated to her.
In respect of the census, the passed by Honorable Supreme Court, also approved by in view of the above, record to inform the minister is not positioned to consider the case till the outcome of the SLP. Yes.
There now the moot question is, subject to what your lordship will say, that if the freedom fighters pension is cancelled, application is cancelled, whether the subsequent legal years accrue any right under any law under the sun.
Correct.
Secondly, my lord, it is well settled law, when High Court actually directs or designates the statutory authority to decide a certain question, and by reason order this has been disposed of, where is the scope for the second writ petition? Because the lordship is not sitting in appeal of a decision which is passed by the authority. These are the number of judgments of the Supreme Court. Where is the scope? Unless it is patently arbitrary and without jurisdiction, this has to be done and gone into by affidavit. Number one. Number two, what he is saying, the Supreme Court has not disposed of the inquiry proceeding against R.N. Giri. That is still pending. Okay. Therefore, there is no question of passing this order and disposing of the matter at the interlocutory stage. If your lordship so feels, we can give a affidavit in opposition. And this cancellation, unless set aside, whether these persons have any right, number one. Number two, I shall be showing to your lordship and annexing the guidelines that if the original application is rejected, and that apart, there is another point I have shown to your lordship on the last occasion, that if during the pendency of the application for grant of pension to the freedom fighter, the applicant dies, the legal heirs do not accrue any right. That is the scheme also. These are matters to be gone into an affidavit.
Okay.
But to that effect, I don't have anything.
No. Then again, they will file the affidavit. Again, the 81. If the Ramapada Panja case is pending,
81. Yes, ma'am.
Ramapada case is pending before the Honorable Supreme Court, what would be the effect?
Lord, today, the matter was appearing before the court number 3 as 118. On 21st, it was directed to be listed on 4th of this month. for which I purchased my ticket on 3rd and 4th, return ticket on 4th. And for that reason, I mentioned before Lordship to fixing a matter of 3rd to other date. Your Lordship will remember. Unfortunately, that matter was not listed on 4th. That has been listed today. I had no option than to instruct my conducting lawyer there to pray for accommodation for that. I have prayed. The matter has not yet been called on. It is going on. 102 was going on when I.
So let that.
Now 106 is going on.
Let the same be decided. Let
So my lord's pleasure is to keep the matter pending and to direct to file an affidavit. But I cannot say that. Pose it up and hear and now.
The petitioner has challenged the impugn order.
I am not of that. আমি জানি অপোজিশন না হলে কোনোদিন মামলা হওয়া যায় না তুমি আপিল কি করতে হবে
Impugn order dated 13th of February 2023 issued by the Ministry, Government of India, Ministry of Home Affairs, wherein it is mentioned that SSS pension sanction by the ministry on the claim application submitted on the basis of the PKC of Sri R.N. Giri is also the petition has filed the present application challenging the order passed by the Minister and 26th of March 2024, wherein it was informed to the petitioner that the ministry is not in a position to consider the case till the outcome of the SLP of Ramapada Panja and others. Ramapanja Panda and other 3 cases pending before the Honorable Supreme Court. Okay? Ramapada Panja and other 3 cases pending before the Honorable Supreme Court. Police Court. The Additional Advocate General, Solicitor General of India has also raised the point on facts, and as such, the court find that the writ petition is to be heard only after exchange of affidavits. Let affidavit be filed, affidavit in opposition be filed within 3 weeks, 4 weeks. Reply, if any, there to be filed within 2 weeks. 4 weeks, 2 weeks. Police staff list the matter on 25th of March 2026 under the same ID.
Can I take back that bundle of orders?
Thank you. Yes.
The next matter is mine, but I have 4 minutes time. I think it can be disposed of.
4 minutes?
Yes. Maybe 1 or 2 minutes more, Muller. Lordship would kindly see the last order.
Item number?
Lordship, I am on behalf of the private respondent. That is respondent number 6 and respondent number 7.
My lord, I am for the entire respondent for number 1 to 5, my lord. We have complied with
last order.
We have complied with the lordship's order, my lord. We have stopped the DCRG, my lord, and we are only paying as per the lordship direction the provisional pension.
Lordship, I am filing the affidavit in opposition, Lordship.
Despite having first wife married again, mine was not being recorded in the service. That's the result of the master respect. This is what someone asking for.
Yes.
And we have complied with it.
To file affidavit in opposition, Lordship.
Yes, file an affidavit. He has said on behalf of client just how it goes. That is not a good. First wife and his son, they are recorded in the service book. That is not principal grievance or because I am entitled, no doubt. Second marriage 33 of the book.
Hmm.
Only what they are saying, out of the bedrock, child was born. So I would not stand in the way. Let three name be recorded in the service book. The restraint order with lordship has passed.
Whose three orders? Whose three names?
First wife,
Children's.
First wife, son, and second wife's daughter. I don't stand in the way. But now he has retired, the amount has to go to an account. Obviously, account has to be opened. Otherwise, the money will not go. Let there be joint account with the name of four persons. The service holder, the person who has retired.
Mr. Day, under the service rules, once the pensioner is alive, now the child and all these things, only with regard to the wife, it has to be recorded in the PPO, and after the death of the husband, only it will be
Certainly,
decided.
after he's there.
I have read that
Correct.
the claim is a premature.
Correct. So
Immature.
recording of the son's wife that in the service book will not serve any purpose. He has retired. This court has already passed an order for release of the provisional pension in the name of the pensioner. Correct. So he will get the provisional pension with regard to the final, because the final will be decided only after the PPO is been issued. The PPO has to be issued when who is the original wife. His photo will be attached with the PPO, and the PPO book will be issued, and automatically once the pensioner dies, then automatically it will go.
After
If the
his
wife
death,
is also died, then if the children are major, nothing. If the minor or a daughter is there, unmarried daughter is there, widow daughter is
Absolutely
there,
correct.
then it will be considered.
Absolutely, my lord.
That is the law.
In this case, my lord, the petitioner son has already attained the majority.
Correct. So if the private respondent is ready, then your name can be included in the service book, and the pension paper book can be issued. That if he is ready.
Lordship, first thing is that the son of the first wife is not a minor at present.
He is major.
Is major.
No, now at this stage, at the time of retirement,
it is
doesn't
immaterial.
arise.
It is immaterial.
The legal heirs name nomination only at the time of during the service period of the government employee, because during the service period, if it's any happen, who will be entitled? Nominee. Now after the death, it is the whole right of the pensioner, he will get the total pension. And after the death of the pensioner, then it will go. That is the law.
Absolutely, older in due course to an extent.
So, no, he just said, my lord, that an account be opened in jointly and all that services.
Let the name of the petitioner be recorded.
But you are ready.
Lordship, I am ready, but one thing, Lordship, in the service book, my daughter's name has already been recorded.
No problem.
Though the daughter is illegitimate, but illegitimate daughter.
Illegitimate for that.
Yes,
no problem.
No problem.
But the pension, at present, the pension, neither the original wife will go, or the second wife will go, or the son. It will go to only the father. So long he is alive.
After
This will
demise
come in
of the
unless there is a due of the maintenance of the domestic.
No.
Then you go to the executing court and file an application.
And that's why the prayer C is not maintainable, Lordship, in this writ petition.
That's this court cannot pass any order.
Lordship.
So if you are ready, then I will dispose of directing the authority to record the name of the first wife and as a wife of the
Wife of
first wife in the paper, in the pension paper book, and issue the pension paper book, release the pension year.
Including
the name of the first wife and as well as the name of the
daughter
of second wife.
That will not come in the pension paper book. That will only the wife will come. You take instruction. If you're ready, your officer.
No, we don't have any problem, my lord. Perhaps he is not aware actually. What is that?
If you take instruction, it can be done. I will pass appropriate order, because which is not permissible under law. The court
certainly, my lord. No, not today. No, not on 2 p.m. No. I cannot take the instruction and come back at 2 p.m.
Which department?
My lord, railway, my lord.
Railway?
My lord,
Which
we are very
railway?
busy, preoccupied.
Eastern.
Eastern Railway, my lord.
DRM
My lord, we got the brief day only yesterday only. In spite of that, my lord, we have been submit. We have acted according to your lordship's direction, my lord.
That is with regard to the restraint order.
Okay. You do one thing, you file a short reply. What is the law? One, how the paper book, pension
Kindly
paper
please for the
can-
next week, my lord.
So you file the affidavit on report by way of an affidavit within
My
a
lord,
week.
my lord.
Give
Much,
this
much
and
obliged.
I will pass it.
Much obliged. Much obliged.
No, because this.
Sir, accept for me.
Otherwise, he will be in trouble. I will. The private respondent has filed affidavit in opposition after serving the copy to the learned counsel for the petition. Let the same be kept with the record. The railway authorities are directed to file a short affidavit, report by way of an affidavit within a week after serving the copy to the learned counsel for the petitioner. This is the matter on 18th of February with 18th of February within 3 matters of the urgent motion. Yes.
18 February. I beg to be excused, my lord. I beg to be
Much
excused.
obliged.
I have 211 urgent matter, my lord.
Yes, sir, just a minute, just a minute. I will come to you.
Yes, my lord.
Yes, I will come to you. Let the senior complete. Which matter? Item number 8.
Madam, giving precedent to me, make it at 2 p.m. I'm sorry, madam, but I could not come at 2 p.m. That's why I bring my other.
Who is for the other side?
Is here. For that extended for 10 times, it will be extended one time more.
800 crore কেন? সব
এই যে।
short করে।
ওরাই তো দিয়েছে, আমি দিয়েছি এটা, নিশ্চয়ই দিয়েছি।
Then it will go March. 12 or 2 p.m. it will be March. Then
কতগুলো আছে পুরোটা দেখি কতগুলো পেয়েছি
2 p.m. it will go of April.
1 to 5.
See my
Item number?
15.
Yeah, give. I am telling you, give the diary to. Not.
Give a day.
Item number? The entry mode is there. Though the matter is especially fixed today as item number 8 at 2 p.m. But the learned counsel for the petitioner is having some personal difficulties and prays for adjournment. He further submit that the entry order is still today, paid for extension of entry order. Still tomorrow, he prays for entry order, extension of entry order. Had the learned counsel for the respective parties, the case is adjourned. I am not telling anything. See. 10th April.
Some mention has been made in the code of ethics. All mentions before the court.
10th April, 2 p.m. 2 p.m. As a specific matter, entry mode is extended till 10th April or until further order, whichever is earlier.
My lord is very annoyed with this gentleman. My lord, probably something happened, but it is not like that. He told me that he is very sorry that he raised his voice. It is not like that. Can you pardon?
No. Since I have taken the determination of this court, I inform all the advocates, and Mr. Day knows when I was in the overlapping argument, I am not allowing. And that to the additional advocate general is mentioning them, arguing the matter is shouting the.
It's not like that.
I don't know what.
That's why, no. Take it that now he is reading Hanuman Chalis. So it is not, it is accident.
Malad, something may happen.
Malad,
You do one thing.
item 200.
The other side, come tomorrow, I will see.
Item 211.
Because other side is not
in
there.
the
In
date
presence,
mein
I
kindly-
pass an order, mention that I will come.
Malad,
Other side can notice the calculator.
দেখলে একে বলে কিছু হলে আমাদেরকে
उसमें बोला ना बाबू एक फाइल एफिडेविट report by an affidavit indicating the procedure and who are entitled to get the family pension.
Alright, I did
For
200.
issuance of PPO. Huh?
Alright, I did 211. 211.
Ah.
May any date may kindly be fixed for
211. What is the urgency?
Not
This is not the time for mentioning.
It is diffusely really planned. I am waiting.
You give the mentioning slip to my court officer.
Your Lordship, completely out of Calcutta, my lord. I am paying most humbly, my lord. Kindly.
Which matter?
Item number 25. Lord, kindly adjourn the matter till 10th of this month, my lord.
Which part? You are for the?
I am for the petitioner, my lord. I inform the other side, my lord.
Record a note.
10th of this
25. As per the prayer made by the counsel for the petitioner, the case is adjourned. Let the matter appear on 10th of February.
Yes, my lord. Deeply obliged.
Yes, call the list.
So my application. I
appear for the private respondent.
My application.
You are for the petitioner?
I'm for the petitioner.
Yes.
Brief conspectus and the petition has been
Prasanna
agitated
Mukherjee.
that the
Prasanna,
I was the transportation carrier for the respondent West Bengal HON'BLE, the Ministry of Textile. I was the tender was floated for carrying the fabrics which is used for making school uniform. Your Lordship, I had participated in this tender on the premise that Your Lordship, the rates at which I have to apply would be the conglomerate rate, bereft of the fact that I must apply on per kilometer basis. Your Lordship, I attempted to participate in the pre-technical bid meeting which was held virtually, Your Lordship. As a result of which this clarification could not be issued. On the date the bid was, Your Lordship, finalized and the tender was opened, Your Lordship, I find that despite me being the lowest tenderer, Your Lordship, on amount of the per kilometer rate basis, the bid has not been awarded in my case. I make a series of representations via email and otherwise, which have been received by the respondent authorities, stating that, Your Lordship, this was a mere technical incompatibility on account of which I have proffered the rates on the basis of a conglomerate unit instead of per kilometer. Your Lordship, those representations are not tinkered to.
When the tender was open?
Your Lordship, the tender was open, Your Lordship, sometime in the month of December. 8th December on instruction and bidding.
So when your tender was cancelled?
The tender was not cancelled. I was not awarded the tender.
Not awarded the tender?
Yes, Your Lordship.
Yes.
I was not awarded the tender despite my bid.
You are the L1?
Yes, Your Lordship. Your Lordship,
So whether the tender was awarded to other person?
Other person who is the scientific respondent over here. Your Lordship, now
So what is your contention?
Your Lordship, over here I am on a sticky wicket with respect to the scope of interference that the Greek court may warrant over here. Your Lordship, two aspects I ought to satisfy before Your Lordship. Before I go to that point, Your Lordship will just kindly take up for once the RFP, Your Lordship, at page number 27. So there is a subsequent fact which I have gained knowledge of. Lordship will kindly take over to turn over to page 28. The Lordship will see the eligibility criteria. 3 Roman 1. The bidder must have an annual average of rupees 45 lakhs turnover.
Where? Page 28.
28. Arabic number 3.
Roman.
Roman 1. Lordship has it at the bottom. Eligibility criteria and related terms and conditions.
That is 27.
Lordship, it's 28 and 9.
27. Eligibility criteria.
Eligibility criteria, Lordship.
Bidder must provide document evidencing minimum 10 to 15 vehicles. The first is the 45 lakhs.
Yes, about 45 lakhs being a prerequisite criteria. Your Lordship, subsequently, we have come to the knowledge of the fact that the private respondent does not satisfy this aspect because Your Lordship is aware. Your Lordship, after the bid is opened.
Where is the document that you are the L1?
That document is, Your Lordship, subsequent to me filing the petition, which is why I am seeking.
No, you are the L1. Where is the document? You are the L1.
Your Lordship, I will not the L1 because Your Lordship, my bid, Your Lordship, it is vitiated on account of a technical aspect. Because I have.
What is the technical aspect?
Technical aspect, Your Lordship, I will not next Your Lordship, and Lordship will kindly take up my representation at page 41.
No, technical aspect might be in the terms and conditions. Where is that?
Terms and conditions. Your Lordship, I will tell you, Lordship.
May I just cut the matter short? It's in the terms and conditions. It's in the terms and conditions.
Where is that?
My Lord will kindly take.
Let me, yes.
My Lord will kindly take the RFP. My Lord will kindly take page 30. Possibly my Lord's brief is 1 page less. Possibly.
Page 30.
My Lord, does page 30 start with XXI?
That is 29.
29, my Lord. 29. The second last clause, my Lord. Kindly give me a moment, sir. Here, my lord, there is a, I am sorry, page 31.
Confirmation of proposal will be sought for L1 bidder. And if the L1 bidder fails, then accept the financial proposal along with the terms and conditions of the bill will be treated as cancelled. And the EMD of the L1 bidder will be forfeited. Yes?
Yes, my lord, kindly has page 29 again, my lord. Has clause C, my lord.
Clause C.
Clause C, my lord, the only clause with subclauses.
4C.
Yes.
4C.
4C, my lord. No, ওটা সাহেবের কপিতে 29.
Yes, 4C.
4C, my lord, to determine the most competitive bid. The tender inviting authority will calculate weighted average of the quoted per kilometer rates from key dispatch locations. Per kilometer rates. It is their contention that they made a conglomerate rate and they did not
made
a rate on the slab basis.
Okay.
And not per kilometer basis.
So how the slab basis?
Cannot be. My simple, may I just, my simple answer is, my lord, barring everything that my lord cannot go into the tender terms, he having participated cannot challenge the tender terms, those I'm keeping aside for the time being. There is a term which says that to determine the most competitive bid, the tender inviting authority will calculate a weighted average of the quoted per kilometer rates from 3 key dispatch locations. The basis of calculation has to be per kilometer. Admittedly, now the writ petitioner, which is the unsuccessful tender participant, has not submitted a bid on the basis of kilometer rates. Good, bad, indifferent, the successful tender participant and everyone else has submitted a per kilometer bid. Milord, as a tendering authority, my hands get tied even if his bid is the best in the world. The second he does not conform to this condition. Because if I say, okay, your bid is the lowest, assuming by 1000 rupees a kilometer it is lowest, and I accept your bid,
okay.
I am
That
now
is only.
Article 14 violation for everyone else.
Where is the rate quoted by you? 37.
12th of December 2025.
No.
This is the first.
37 is the 9th of December email. 39. 38. Yeah, 12th of December.
12th of December.
Correct.
That the rates submitted in the tender was mistakenly entered as total rate format instead of the intended per kilometer.
Correct.
I'm not falling from quantity with that fact. We also confirm that we are not submitting any corrected quotation.
Correct.
We have only recalculated the same submitted quotation on a per kilometer basis, and as per this calculation, our rate stands at L1 in all cases. Subsequently, I proper the calculation. So that aspect, obviously, I keep not going.
I am not joining issues that.
I am not including the fact that we not made a false. So only with respect to a correction in the calculation.
Sir,
my hands are
the
tied.
tender document, what the tender condition required, that you have to follow. It is not that they have import a new condition which you have no knowledge. Then after the new condition, you are requested, I will follow this and I will follow this. There is a terms and conditions with regard to the per kilometer. You have to given the rate. You have not given the rate. You have given the bulky rate of 4,000 or 5,000, whatever it is. So now you have made the representation that your rate is to be calculated. If it is taken in per kilometer also, it will be lowest L1.
When did the bid close?
One aspect that I want to recall by way of a supplementary respect to the fact that they do not conform with the eligibility criteria. So that is also I will satisfy also once I can bring up the supplementary. I don't have that.
And Milord, that is bereft of the grounds and the pleadings.
If suppose tomorrow you will bring the document on record, what will happen? Only you have to go to the compensation, not the tender.
Probably not. I probably talking about. Lordship knows when there is inherent lack of jurisdiction.
Inherent lack of jurisdiction. If it is now, if tender has been issued,
work order issued,
work order
agreement
issued,
happened.
What can
Work is has already started.
I'll come back and satisfy on that also.
The counsel for the petitioner prays or file the supplementary affidavit. Let supplementary affidavit filed within a week after serving the copy to learned counsel for
In
the
the
respondents.
meantime, may I just for
Reply
one
if any. Yes.
I'm sorry. First time I could not be spotted in a room, my lord. First time I was blocked by someone else in a room, my lord. Anyways,
You are blocking all.
Otherwise, yes. My lord, may I just say this? My lord is keeping it as my lord, please. In the meantime, my lord, may I come back with an affidavit to this? There are documents.
That let the within a week from date after serving the copy to the land counsel for the respondents. Reply get it in. The respondents are liberty to file their affidavit in opposition with regard to the writ petition as well as the supplementary affidavit if any within 2 weeks. Reply if any thereto within a week thereafter. List the matter. कितना हुआ 1 week 2 week 3 weeks or 2 weeks 4 weeks होगा ना नहीं फर्स्ट में सप्लीमेंट्री 1 week 1 week 2 week 2 week 5 week हुआ ना 5 week हुआ 5 की तारीख है 6 let the matter appear on 17th March. I will take it. The urgent motion, it will come under the heading urgent motion.
So very obliged.
Next.
I am for the respondent, my lord.
Yes.
I am appearing for the Union of India.
Yes. Yes. In January 2026, yes. Then correct. Correct.
By directing the petitioner, making regard to the petitioner to make an application for renewal of the leave and license agreement in terms of the condition number 6 of the leave and license agreement.
Correct.
And it comes to page.
Where is the order?
Page 80.
Huh?
Page number 80, my lord.
80.
80.
11, page 84, that is paragraph 40.
$80.
80, next year P8, my lord.
From 80 and 11 question is page 84, paragraph 40.
84. Yes.
Considering the court finds that the offer made by the respondent that the petitioner shall consent the premise in question till January 10, 2026, and thereafter the petitioner shall vacate the premise good offer. Thus, this court accepted the offer made by the respondent. The petitioner is directed to vacate the premises on January 11, 2026. Then, if the petitioner intends to continue with the premises, the petitioner can make a representation to the authorities from date and if it is made by the petitioner, authorities shall consider in terms of fixed of the agreement within a period of 3 weeks from the receipt of the representation of the petitioner and pass a representation.
Correct.
Then, I have made a representation. That is that page 94.
Yes. Then what does happen?
Thereafter, for similar type of order without giving any reason, that is at page 98. What happened in the meantime, the respondent will receive the license from me for the period from July to March 2026. That is that I have answered the same. That is at page 79.
79. Collection, CD Patna. Online payment.
Online payment.
Receipt. Online challan receipt by hand, that is date 28th October 2025.
Where it is? 26th October.
Payment bill period duly July 25.
Payment of a bill for 13,334 for
March
July
26.
25 to March
26.
Correct. So what about you are still in possession of the property? You are still in possession of the shop room?
No, my lord, that.
No, that has been you have been evicted.
Vacated.
You have vacated the premises.
Vacated the premises.
In the meantime, 12 January, during the pendency of the restriction, padlock my shop.
Correct. I am telling that whether you are still in occupation of the premises.
No, my lord. Vacated the 12th January.
I am vacated.
Hmm.
I am restraining by the respondent.
Who is in occupation of the premises?
Well, our cooling period.
Whether the shop is allotted to any person?
No, my lord.
No.
My lord, order can my lord.
Where is the order?
Impugn order at page 98. Without any reason, similar type of order was that.
Page 98.
Page 98.
98, para 2. The license period or allotment shall be subject to 5 years with the 3 years cooling or break period. There is no provision of extension of time period beyond 5 years in the policy. And as per you,
Okay, the license period is over. So what is the status of the shop premises?
Now vacated, my lord.
Yes, you are appearing for Mr. Majumdar.
Union of India, my senior colleague is pleading, my lord.
Yes. So what is the position of the shop premises? Whether it has been allotted to any person or is still lying vacant or what?
My lord, page 83. Order. Page 83, lordship's order.
Correct. I have seen the order. This with regard to the March 2026. March 2026, there was a. Oh, then he will vacate. Kindly come to the order.
26 January 26.
Yeah, January 26.
26.
Correct. January 26, he has to vacate.
But as per court order, he will
and he can make a representation. That's why
and representation is rejected.
Well, that's why I'm telling.
That is the already vacated court.
That order can be right. That without that has nothing else to mention of order. But can you please 98 page 98?
Correct. What is your right?
My right, because I have paid them.
Okay, record an order.
Up to
The petitioner has filed.
I have paid them. But
authority assured the excess payment is the will refund.
Why you have accepted the rent?
No, my lord. This bill procured by the e-bill. Who this procured the petitioner is the procured the July to 26. Order was passed. Most probably consider this bill.
Why is that confidential?
13/11/2025. 13/11/2005 order was passed. 13/11/25 order was passed.
On the contrary,
Record an order. That's all. That's all. Yes, I have gone through.
You are advised to hand over the shop to GE Alipur and confirm to this occupied 18 January 20.
Okay, record. The petitioner has filed the present date application challenging the impugn order dated 6th of December 2025, wherein the request of the petitioner for reallotment of the shop number 06, command 06, command HOSP EC complex Kolkata is rejected. It's rejected. Counsel for the petition submit that as per the agreement entered between the lease agreement entered between the petitioner and the respondents. The tenancy period was up till the 10th of January 2026. But during the continuation of the tenancy period, the respondent authorities have issued the notice for eviction, and according the petitioner has challenged the said notice before this court. According the petitioner has challenged the said notice before this court in a writ proceeding being WPA 15820 of 2025. Police. This court, by an order dated 13th of November 2025, disposed of the writ application by passing this said order. Record page 84, paragraph 13, 14, and 15. Okay, 84, 85. Police. Counsel for the petitioner in terms of the leave granted by this court has made a representation for consideration of the case for extension of the lease period. But the authorities have rejected the request. On the ground that the license period oblique allotment shall be subject to 5 years with a 3 years cooling off period. And there is no provision for extension of time period beyond the 5 years in the policy. Police. In the police stop, the learned counsel for the petitioner submit that there is a clause in the agreement itself for renewal, but the authorities have not considered the same. And have rejected the request of the petitioner. Police stop. The case of the authority, in the specific case of the authority, is that as per is that the reservation of shops for allotment semicolon 100% reservation for war widows widows of defense personnel killed while on duty, disabled soldiers / ex-servicemen and spouses / widows of the ex-servicemen, etc., shall be followed for allotment of the regimental shop in various formations / establishments / units. He further submit that the period of allotment oblique license shall be subject to 5 years with the 3 years cooling off break period. It is found from the record that the petitioner is in occupation when the initial allotment was made. It is found that the initial allotment was made in favor of the petitioner in the 2012, and since then the petitioner is in occupation of the said premises. Thus, this court finds that the authorities have acted in accordance with the guidelines as the petitioner was in occupation of the premises in question more than 5 years. Full stop. The petitioner has also relied upon the e-money receipt and submit that the respondents have accepted the payment of the rent of the premises from the July 2025 to March 2026, but the authorities are not considered the same. Full stop. This court failed to appreciate that on the previous occasion, then when the petitioner has filed the writ application being WPA number 15820 of 2025, the petitioner has not brought the said e-money receipt and has not taken any plea that the petitioner has paid the monthly rent till the month of March 2026. It was the specific case of the petitioner that as per the agreement, the tenancy period is only up till 10th of January 2026. And this court and the authorities allow the petitioner to continue with the premises till 10th of January 2026. This court also find that this payment has been made by the petitioner on 26th of October 2025 on online payment. At that point of time, the tenancy period of the petitioner was in existence, and thus the authorities have inadvertently accepted the monthly rent. Accordingly, this court does not find any merit that the petitioner has paid the monthly rent till the month of March 2016. The agreement is to be extended. Considering the above, this court did not find any merit in the present date application, that petition is dismissed.
Much obliged.
So you will vacate. When? When you will vacate. So you tell I will fix the date. When you vacate, I will record your submission.
I will vacate to
When?
12th January. January already vacated.
And during the pendence of the
Okay, whatever it may be. Yes, when you will vacate, I will record you. The petition is directed to immediately vacate the premises and hand over the same to the authorities. Yes, what you are saying?
Vacated
Already vacated.
vacated. 12th January already vacated.
Next.
Much obliged.
My lord, I beg to appear on behalf of the
Not today, come tomorrow evening, morning, at the time mentioning.
petitioner education. My lord, I'm just indicating, my lord, this matter, my lord, similar matter, your lordship has passed an order yesterday, my lord, with the bar council election. My lord, I have handed over the notification. Now the notification pursuant to your lordship's last order, the notification is there, the election has commenced. The high-powered committee has taken charge. My lord, the writ petition at present is not maintainable before the High Court in view of the Supreme Court's order, my lord.
Yes.
Any grievance they have to make before the committee.
Is any there? No one is there.
Prayer is, my lord, if your lordship kindly sees.
But already notification has been issued.
The lordship has directed
Election
only to
process
produce the
started.
notification. On the last occasion, the
What is your
notification.
prayer?
My lord, there are several prayers. My lord, that your lordship will get. I'm telling you, my lord, the lordship prayer starts at page 40. He has also amalgamated a different prayer of a different nature, mismanagement of fund by the West Bengal Bar Council. That is neither here with the writ petition, my lord, with the Bar Council election, not there. Your lordship on last occasion directed them to file a separate writ petition for that score.
Yes.
Password.
Short password.
Then, my lord, kindly, if it comments to kindly make it not today, my lord, if it comments to your lordship.
Not today. Next.
I am for the petitioners, my lord. 19 minutes.
Yes.
Let the clients know they don't wish to continue the proceeding. My lord, lastly, I indicated it as a written instruction.
My lord, I am appearing on respondent number 3.
The Learned Counsel for the petitioner has handed over a written instruction dated 19 January 2026, wherein the plaintiff has requested the learned advocate on record of the plaintiff
For the state, my lord.
that the petitioner is not in petitioner is not interested to proceed with the matter and requested the petitioner and requested the advocate to withdraw the writ application. In view of the written instruction, counsel for the petitioner prays for withdrawal of the writ application. Consider the submission made by the counsel for the petitioner. Peruse the written instruction dated 19 January 2025, WPA number 448 of 2026, within bracket Mandal Stone Products Private Limited versus State of West Bengal, is dismissed as withdrawn. Interim order, if any, stand vacated. Copy of the instruction be kept with the record. Yes. Give your name. Next.
My lord, item number 20.
Yes.
My lord, I appear for the respondent number 4. Hello, right, my lord. Service is complete. There's an application, your lordship. Very short prayer praying for unfreezing the bank account, your lordship.
Unfreezing? When it was freezed?
Yes, lordship.
When it was freezed?
Your lordship, it was, your lordship kindly come to in the month of September 2025, the bank account was frozen for no reason, and subsequently we have reverted back to the bank authorities, requesting them to unfreeze the account.
Who is for the bank? You are
I am appearing for the bank.
Which bank?
Kotak Mahindra Bank.
Yes.
But the matter was assigned yesterday. Well, I need some time to take instructions in this regards. But my whole livelihood is being affected. I am just an Uber driver, and thereafter for no reason. Kindly keep it in the next Monday, it will be great. Period for no reason. We are completely in the dark why it was frozen. Thereafter, we reverted back through email. We have followed it up.
Okay, you file a report. When? Monday?
Monday.
Come on Monday.
I mean, led by Mr. I will come.
I'm sorry, I came at the very fag end of the matter. Coming from the criminal courts to this.
No, he is telling that he has received the brief that I am fixing on Monday under the same heading.
Because my
correct, I understand.
Lordship understands what is the amount.
I understand, but the bank let he take instruction.
Very well, my lord.
I will come with instruction.
Learned counsel for the bank submit that he has received the brief only yesterday and prays for time to take instruction. According cases adjourned, let the matter appear on 9th February under the same heading.
Time could be fixed.
Same heading, urgent motion.
Deep regret.
Next one.
Lordship, in this matter, I'm appearing for the Union of India. I'm led by the learned Additional Solicitor General, Your Lordship. Your Lordship, in this matter, only the Union has been made a party. However, the regional passport office, the district passport officer, none of them have been made parties, Your Lordship. So, Lordship, we're not being able to seek instructions.
You are appearing?
Yes, my lord. I'm appearing, my lord. Thought issue, my lord, is with regard to the release of my passport.
But where is the regional part?
My lord, that is, my lord, what we can, my lord, do, my lord, subject to your lordship's convenience. If this could be kept on Monday, in the meantime, my lord, liberty may be given to add them as parties in the cost.
You add the party, serve the notice. I am fixing on Wednesday.
Much grateful, my lord.
The Learned Council appearing for the Union of India submit that the petitions only made the Union of India as a party and has not made the regional passport officer and other authority as respondents who are the necessary party in the present date application. Council for the petition submit that by Monday the petitioner will take appropriate step for addition of parties and police in view of the
Your Lordship, even the CJM Barashat, Your Lordship.
No.
Because they say that the passport has been. It can't be made a party, Your Lordship, but they say that the passport has been withheld by him, Your Lordship.
Let me see.
We will do that, Lord.
By Monday, copy be served upon the added respondent. List the matter on 12th of February.
I'm grateful.
Under the same heading. Next.
My lord,
I am appealing for the petition.
my lord, in this matter, Mr. Amol is appearing for the state, my lord. He is engaged before the Honorable Justice Smith is there, my lord. I am praying for not today, my lord.
What is the need for final submission of the final bid law? The matter is a tender matter. It is vital matter of because the violation of the Article 14 and Article 19 1G has been done by the concerned authority. That is the people of the
What?
They have done violation of the memo issued by the finance department was Bengal. The memo was issued. That is the point.
No.
I want to submit the memo.
Where is the memo? Where is the memo?
Nothing.
Lordship.
The page number.
My lord, I am for the respondent for 4 Birbhum Jilla Parishad. But today only I have received the information that we are appearing in the matter. I am yet to receive the power also, Your Lordship. So, my lord, I am without any instructions, Your Lordship. That is the difficulty.
So what is the last date of the tender?
Yes, sir. Tomorrow is the last date of filing the submission of the bid. Because I am the ineligible to participate in the tender proceeding because of the illegal, malafide as well as arbitrary tender notice was issued.
Which clause you are which clause you are harping upon?
Yes. Put that. Can you come to the annexure 7? P7.
When we don't have the copy.
P7. This is the terms and condition of the tender, which was issued by the Birbhum Jilla Parishad on 14/1/2026. First, kindly see the 7 law. Value be deposited as EMD through online transfer In place of 10%, it should be 2%.
Where which clause?
That is the annexure P7 of first page,
Hmm.
clause 7.
10% of the base value
Yes, sir. In
to be
place of 2%,
deposited.
they indicate the 10%. This is a violation of the
What?
2% is the EMD. In place of 2%, they indicated 8% of the base value is to be deposited by the participant, which is illegal. Can you see my
কে কার হয়ে appear করছে?
ও জেলা পরিষদ
Yes. Yes, which clause?
প্রথমত জেলা পরিষদ
মানে
যে যে আছে শেষে নেই, ব্যাপারটা এইরকম।
Where is? Which clause, sir?
Sorry.
Which clause?
নম্বর করো।
Clause 1.
Clause.
Yes, page, six page. Clause 1. The general condition of the contract. The earnest money, the person who intends to participate in the tender of an estimated amount of rupees 25 crore shall have to deposit earnest money at the rate of 2% of the estimated amount put to tender or in that whichever is lower. This is the one clause. They violated it.
Okay.
Second point is mine. Second point, I will come to the annexure P7.
P7, yes.
Yes, P7.
7.
P7.
P7.
They indicated
Last annexure.
terms and conditions. The terms and conditions, that is the A. The contract has been for a period of 3 years. Should be 1 year. So many Jilla Parishad has published the
What is the tender for?
tender form is
What is the tender for?
tender for the
collection of
collection of the
Toll plaza. Okay. So why you are telling that it should be only 1 year?
Yes.
It is all.
With regard to this state document, I am saying that and placing that document. Finally, where the landlord is given one.
Maybe last year 1 year. Now the authority considered it should be 3 years, 5 years. That is the authority. How you can dictate? It should be 1 year or 2 years or 5 years. You cannot dictate. Only with regard to the memorandum, I will take the ask the question from the authority. With regard to the year, it is.
They cannot have the right to impose the regarding the assignment of the sale. And this is the annexure P7 clause 1. That intending tender bidder must upload the credentials for at least one physical assignment related to the collection of the toll, having an contract value of not less than 40% of the base value of the present assignment. The assignment must have been awarded by the competent authority within the last 3 years.
Correct.
From the date of the. This is the violation of the article.
So how the authority will identify your credential unless and until this is not. If you're not having the experience certificate, having the tax collection, you're not having the more than 40% of the base value, how your credential can be verified by the authority, sir? No, 14. Yes, Mr. Sin, what about this clause 7 of the terms and condition auction notice? 10% you are asking? P7 clause 7. 10% of the base value be deposited. Be deposited.
As earnest money to online transfer. Yes.
No, but this memorandum, you are having the memorandum of Government of West Bengal Department of Finance Audit Branch. They are relying upon, see that the clause 1, it should be 2% if the 25 lakhs, not more than 10 lakhs. Clause 1, earnest money. Yes. So if it is there and it is the memorandum of the government, how you can how the Jila Parishad can take the 10%? That is the only question.
Issued by the
Jila Parishad.
Jila Parishad. Under one of the different,
No, finance department. Finance department of the government is covered the whole. It is not that it is the if it is department is different thing, then I could have been understand. But it is the finance audit branch. That's it. That is
the experience, that
I am not on that. I am not other two conditions which the petitioner has relied upon. That I am not on that. Only with regard to the clause 7, 10%. If it is not more than 2%, how you can turn to it?
Yes. Consideration of one or two paragraphs of this judgment reported in 2019 OACC page 401. My lord, with regard to that, my lord, the question of my lord, the tender condition.
One thing before going to, what is the value of this tender? More than 3 crore.
More than 3 crore.
Okay. Because this memorandum also says applicable for the works value up to the 25 crore.
Up to 25
crore. So it is coming under that. Yes. Which portion?
Kindly come to my lord, the paragraph number 9 and 10.
Yes.
Paragraph number 9. It is well settled that the terms of an invitation to tender are not open to judicial scrutiny as they are in the realm of contract unless they are arbitrary, discriminatory, or actuated by malice. Thus, in Directorate of Education versus Educom Datamatics Limited, this court held it is well settled now that the courts can scrutinize the award of the contract by the government or its agency in exercise of their powers of judicial review, even arbitrariness or favoritism. However, there are inherent limitations in the exercise of the power of judicial review in such matter. The point as to the extent of judicial review permissible in contractual matter by inviting bids by issuing tenders has been examined in depth by this court in Tata Cellular versus Union of India. After examining the entire case law, the following principles have been deduced. The principles deducible from the above are: the modern trend points to judicial restraint in administrative action. The court does not see it as a court of appeal, but merely review the manner in which the decision was made. The court does not have the expertise to correct the administrative decision. If a review of the administrative decision is permitted, it will be substituting its own decision without the necessary expertise, which itself may be fallible. The terms of invitation to tender cannot be open to judicial scrutiny because the invitation to tender is in the realm of contract. Normally speaking, the decision to accept the tender or award the contract is reached by process of negotiation through several tiers.
more often than not, such decisions are made qualitatively by experts. The government must have freedom of concept. In other words, carefully in the joints is a necessary concomitant for an administration.
That's correct. That's I correct. Only kindly come to the page for. Yes, no, kindly come to the page 407, the subpara 12, fifth line. Para 12 on the same, the subpara 12 thing. The court would interfere with the administrative policy decision only if arbitrary, discriminatory, malafide, and acquitted by bias. So here only the question is that if your memorandum says with regard to the 2%, can you? That is the only thing. So I am not going with regard to the other countries. That I already restrict. That's why I restricted the petitioner.
No, only one thing.
Yes.
That is a. If that is be so, circular would have been handed over to us. We could not find that circular finally. But so far as the petitioner is concerned, petitioner was well aware of the fact that the tender was being called 10% security money. He would have come earlier because from the tender I can show your lordships that there was a pre-bid meeting. The pre-bid meeting had taken place on 20 January, which the petitioner knew. In the pre-bid meeting, he would have appeared and says that why 2% security? Why not 10% security? And what happened, my lord? In this large amount of tender cases, if there is 2% security, in that case, they will not proceed with the work also. It is a large amount of tender.
But you cannot go by the memorandum of your government itself. You are the Jila Parishad.
Then, my lord, the entire tender cannot go. Let them participate in the tender.
No, then I will pass an order. Not I am not staying the proceeding. You give the corrigendum instead of 10%, it may be read as a 2% in compliance of the memorandum dated so and so.
Then, my lord, that have to be, my lord, dealt in with by us. But in that case, he may be allowed without subject to the, without prejudice. Then I will come with the affidavit why I have not done. But he may be allowed with 2%.
If it is allowed, okay, I will allow the thing. And what will happen to the that you will retain the tender process stalled.
Fact is this, my lord, the persons who have done this,
if it allowed,
who have deposited the 10%, that is already going to be.
You cannot continue because the memorandum says
I have to take instructions regarding that. I am not saying that it is complete. It may be happened that there is maybe corrigendum against that also.
Maybe.
So if 2% persons are being allowed, in that case again.
Okay, in that case, I am passing an order. He may be allowed with the
2%,
but you not conclude the tender process. You file a short affidavit within a week. You will file the reply.
Conclude. Well, let it be fixed on next week itself.
The person who is doing collection of toll plaza.
That's why
he will be benefited.
That's why the London advocate is.
And that is also going on without any tender also within 4 years.
Constitution of the tender process, which is pending before the after getting that have been published the notification.
No. That is pending. That is
publication of the tender notice, and that notice they are violating the norm. That is to be
in any event. That is pending. So that's what no.
Let it be taken up next week or within 2 weeks. That will not conclude within 2 weeks. In that case, I will come with a final affidavit or report.
That's why I'm telling. I will allow you one
final report, and I will come there why we have not followed. But a copy of the notification may be given to me. The memo but let it not be stopped. My lord, I will come with a report, and thereafter I will.
So what will happen if you allow to participate, and tomorrow you will allow the work to the third party? Then what will happen?
No. Fact is this. Tender will not be concluded.
If you assure that within 2 weeks you will not conclude the tender process, then I will record your submission. I will not record the stay, but I will record it.
Subject to.
I will record.
May I tell one thing? My lord can also dispose of this. Whoever my lord participated by my lord depositing 10% in terms of the late should not be disturbed. But the petition subject to my lord.
petitioner, the petition be disposed of, allowing him, my lord, upon my lord, putting 2%. That is, my lord, the maximum.
2%, yes.
And my lord, tender process be going on.
Yes. So what will
Without
happen?
prejudice, my lord.
So what will happen? How the authority will consider 2%? He will also participate. So if suppose as per the he is L1. He is L1. So whether you will give the tender?
No. If he is
unless the adjudication is done by the whether it is 10%.
My lord, I am sorry, my lord. I am intervening. I am sorry. If the 2% person who has come before this court, others I have not approached, who have come before this court, if he is otherwise eligible, that may be recorded in the court, in the order. Then the court, we will automatically, if he is eligible, and many things happen after that also. My lord knows it. I will not show. He will go and efficiently go and get it. That I know. But fact is this, my lord may dispose of the petition, thereby directing that if he is eligible, he will be then granted the tender. But so far as in case of others, in
that case, I am allowing the disposing of the writ petition, allowing you to participate with the 2%, with the 2%, and if the authority found it is eligible to get the work order, it can be proceed.
Exactly.
And with regard to the 10% or 2%, that will be decided at the on exchange of the affidavit. Exchange of affidavit. And I also telling, if this court found that 10%, if you are L1, subsequently you have to file the 10%, give the remaining amount.
Exactly, that is to given. Give that. It is a huge amount.
That will be decided during, because might be there was a corrigendum, there is a addendum or whatever it
that
may
I have
be.
said. That might be a corrigendum also. And let a copy of the
petitioner has
circular may be given.
Filed the present writ application against the condition of the tender.
May I take this one?
Yes. Against the clause 7 of the terms and conditions of the tender, which reads as follows: 10% of the base value to be deposited as EMD through online transfer only to account number 052801002557, IFC code ICIC 0000 528 branch Suri through NEFT RTGS, and a copy of the transaction shall have to be uploaded in the portal. The contention of the writ petitioner is that the authorities, the Birbhum Jila Parishad, have put the said condition in the tender notice in violation of the memorandum dated 1st October 2019, being number 5696-F within bracket capital Y, issued by the Government of India Finance Department Audit Branch, wherein, as per the general terms and conditions, the earnest money, general terms and conditions, clause 1, the person who intend to participate in the tender for an estimated amount up to rupees 25 crore shall have to deposit earnest money at the rate of 2% of the estimated amount put to tender, or rupees 10 lakhs, whichever is lower. Full stop. Counsel for the petitioner submit that the respondent authorities have violated the terms and conditions of the memorandum dated 1st October 2029 by putting the condition for depositing the 10% of the base value of the EMD, as EMD instead of 2%. Full stop. Learned Additional Advocate General appearing for the state submit that this court cannot interfere in the tender process. The terms and conditions imposed by the authorities of their considering that the authority has to see that the tenderer shall execute the work work even if the work order is issued. He has relied upon the judgment in the case of ICOM Tele Limited versus Punjab State Water Supply and Sewage Board and another, reported in 2019 within bracket volume 4 SCC, and submits that and submits that the court does not have the expertise to correct the administrative decision. If a review of the administrative decision is permitted, it will be substituting its own decision without the necessary expertise, which itself may be fallible. Full stop. Full stop. The learned counsel appearing for the Jila Parishad submits that the Jila Parishad had put the condition of 10% only to ensure that if the tender is awarded to the tenderer, he should complete his tenure. If the 2% is been fixed as a EMD, the tenderers, there is every chance the tender may left the work in the mid of the tender period. Full stop. Had the learned counsel for the respective parties produced the materials on record. This court find that in clause 7 of the e-tender notice, the Veerbhum Jila Parishad has put the condition for depositor of the EMD of 10% of the base value, but as per the memorandum dated 1st October 2019, the person who is intended to participate in the tender for an estimate amount up to rupees 25 shall have to deposit 25 crore shall have to deposit earnest money of 2% of the estimated amount put in tender, or rupees 10 lakhs, whichever is lower. In the present case, it is submitted that the tender value is rupees. What is the tender value? About 3 crores, about 3 crores, and as such, the clause 1 is squarely applicable in the present case. Thus, full stop. The learned counsel 3 crore 4 lakhs 52,280. Okay. Full stop. The learned counsel appearing for the Jila Parishad submit that he may be granted time to file affidavit in opposition to justify why the authority have put the condition for depositing of 10% EMD of the base value. Full stop. Considering the submission, full stop. This court find that, and this court prima facie find that that as per the memorandum dated 1st October 2019, the authorities cannot compel the bidder to deposit 10% of the base value as EMD. The EMD should be 2% of the estimated amount. Accordingly, the petitioner is according the respondent authorities, particularly the Veerbhum Jila Parishad, is directed to allow the petitioner to participate in the tender process with respect to the tender notice number WBZ-P-B-HM-10-10-2025-2026 dated 14th of January 2026, be memo number 209 BZP by depositing the 2% of the base value, depositing the EMD of 2% of the base value without prejudice to the rights and contention of the authorities. Full stop. It is further made clear that the authorities found that the petitioner, after participating in the tender by by depositing the 2% EMD of the base value, and the petitioner is eligible to get the work order, the respondent authorities can issue the work order in favor of the petitioner that is subject to outcome of the present writ application. It is further made clear that in the writ if the petitioner is been awarded the work and finally in the writ petition it is found that the petitioner has to deposit the 10%, the petitioner has to deposit at the and is liable to deposit the said amount. The respondents are directed to file affidavit in opposition within 2 weeks. Reply, if any, thereto within a week thereafter. List the matter on 18th of March 2020. Yes. No, I am not. You go and submit today. Go and submit. You will get the evening. You inform that. What? That's why he recorded. He has to pay the remaining amount. Okay. Yeah. Okay. You do, that is not here. You do one thing. You inform your authority and you deposit the amount. Adjourn motion. Adjourn motion. Or do you come karo under the heading orders karo. अच्छा hearing में रख hearing में करो. Yes. किया छे. Which matter? 3 p.m. Original site. You are appearing. Response number 2 is the Union of India.
Your Lordship, I'm appearing on behalf of SFIU.
SFIU, you are appearing?
Yes, sir. Yes, Your Lordship. I'm appearing on behalf of SFIU.
Yes.
Lordship, we have not served with the copies, and I humbly seek time for seeking instructions from the department.
Yes. Yes.
The petitioner before your Lordship, the specialist in cancer drugs, the pharmacologists and specialized cancer drugs, now presently one of the pioneering researchers on radioisotope technology and radioisotope with half-life. Inserted attacks the cancer cells and destroys. But when he started his career, he was employed in Elder Pharmaceutical. That is in 2006 to 2009. And
in India.
In India. So initially he had started in another well-known pharma company. Then in Elder, why I am mentioning Elder? Because the investigation is relating to Elder Pharmaceutical. I found it. So 2006 to 2009, he joined in a 2-year category. 3 years he is promoted to a general manager. 2009, he resigns from India, goes on to he starts his own business, goes to Bombay. His company was also successful. Then he gets into the packaging of these cancer drugs for the limited purpose. He joined another company in Bombay. Also employment he is sent to China. And in China, he joins another company where his present is AD Global. He is working in AD Global, who are the world leader in so far as oncology drugs, packaging and is concerned. From 2013, he is working with AD Global in China. And he is settled in China in the sense that he has married a Chinese citizen over there. They have family children. His parents are in Calcutta. He has a sister in Calcutta. Every year, at least for 7 to 8 times, he is regularly coming to Calcutta and going from Calcutta. And after 2009, he has no connection with Elder, save and except Elder being in same oncology business. To the extent their business with the SEDI Global in China, some expansion program, some reference was made. And in Elder also, he is neither a director nor in any shareholding capacity, no connection whatsoever, no managerial position whatsoever. He is an expert on oncology. Now, in this background, even in the regular Christmas vacation in 2025, he, along with his wife and children, comes to Calcutta to visit his parents. But on 21st of December, they were to leave. Their tickets were there. He was leaving on 21st, but he was stopped because from here he was to visit en route from Bangladesh to China or Thailand. That is his current posting. The company is in China. He is presently working in an hospital in Thailand. So he shuttles between China and Thailand. And he was to go via Bangladesh because another cancer hospital is also their client. He was to administer transfer. He stopped, saying that there is a lookout circular from the SFI in relation to proceedings against elder parties. Well, the only connection he has from 2006 to 2009. Then, he recalls there is the only mail that he received in January 2025. There was a mail that was in China. His email ID is in yahoo.com. Now, in China, Yahoo, you cannot open any annexure with Java. So he opened it much later. That was the first time SFIO had sent him a sample. Be that as it may, when he is detained over here, he visits the office of SFIO. But all they ask him is, what is your connection? He says, I am only a medical expert or a pharmacology expert. I have no other connection with this. And whatever he had to say, he said. Then they ask him, because to enter SFIO office, you have to keep your mobiles and everything locked. They say, all right, he types the mail, he says, write a mail, and you will provide us all documents that you have. He even writes a mail, and he sends, because he opens the locker and gets that mail. That is also on record. We have confessed now. Then he says, what further you want? He says, no, you are done. So he thinks he can leave. So because airline tickets are expensive, 28th of December, he tries to meet because he has to attend his clients in Bangladesh. He books a ticket to land and he wants to go to Bangladesh, go to those cancer hospital. He again stopped saying that the lookout circular has not been removed. It's still there. So twice he then whatever it is, whoever gave him advice, he files RTI and all that, and he finds out ultimately he is told that no, he can't do anything, you have to get it washed. And unless there is a court order, internally this is what is there. Same point of law is very simple. Even as on date, SFIO is barely investigated. There is no final investigation, there is no interim report. There is no clause of that circular of 2022 which Lordship had the occasion to consider as this violation. That is of course, in final argument after affidavit they will see. But today I am only asking an interim order. That and all our division bench and even division bench of Delhi High Court, I come 7 or 8 times in a year. But I am giving undertaking whenever they want. I only need 15 days advance notice, and I give an alternate email ID of my advocate on record. You want, I will come and I will be at your back. Why 15 days? I would have come in 2 days because once a drug is administered, it takes 7 days because of the half-life of the drug, from 2 to 7 days. So if I am in the process of administering a drug, I cannot come without completing that. That will be dereliction of duty. Therefore, I am asking 15 days. Let them file their affidavit. I am giving an undertaking that I will come within 15 days notice if I am required for the investigation. In law, there is none of the clauses in the memorandum, there is no cognizable offense so far as I am concerned. None of the other clauses. And with either pharmaceuticals, other than my employment from 2006 to 2009, I do not have any connection. And Elder Pharmaceuticals were taking consultancy service from my company, but I was referred only consulting only. Well, what has really happened, and I got to know from the SFI office, when they were investigating in some document, my name cropped up. So, well, and because they are dependent on mail, and China and Bangladesh are not the power countries now, well, it doesn't give a good impression. I also sort of questioned my own client. I had no other place to go. But this is the position. But he is a medical expert, a pharma expert. He has nothing to do with corporate fraud. And I am undertaking whenever they will work. And whether he is also present in court, whether kindly see the urgency is whether not you will see the letter. For 1.5 months, if I neither report to my employer in China, page 122, not you will see. I have been given an ultimatum. If you don't join, we will take other action against you. Who will disburse salary or keep me in employment just like that? And even for other citizens, they may have some sympathy, but for Indian citizens, Chinese company will not have this.
Yes.
So, this is at the investigation stage. Doctor has already given a final judgment. It's covered by others. I am only relying upon for the interim order.
Have you the LOC?
Yes.
LOC? No, you're not disclosed here. There is no LOC. Yes.
And in all cases, Lordship will find they
We are calling for.
Lordship will call for that and see it. But this is the judgment matter for the injury model I am relying upon. Kindly have a look at paragraph 4 of it. Kindly come to paragraph 10. Therefore, the question that arises before this court is whether the lookout circular initiated by the bank and acted upon by the inspection authority is legal and was issued considering all applicable rights. Having heard the learned counsel and a producer of record this court is of the petitioner was a director as it appears and application for loan. Even here, he was a director. He is not in the managerial capacity. Done by the accused was Dhananjay Singh, the managing director. Moreover, the name of the applicant does not appear in the sheet. The means to repay the back loan. Furthermore, as held in Manoj Pushkar Koshiwal, of India, this is again a Calcutta. Recourse to LOC can be taken by the investigation. Cognizable offence under Indian Penal Code or other penal law, where the accused is deliberately evading arrest or not appearing in a trial court despite using certain measures, and there is a likelihood of the accused in the country to evade trial or arrest. The present matter, the appearance petitioner has traveled overseas countless times and on each occasion returned to the country after accomplishment of voyages. Moreover, appearance never been summoned.
When is supposed to go?
If I buy a ticket and I don't go because of LOC.
So that's why. So what I propose to do, let the this SIFO is also there and is there. I am directing to file a report by Tuesday and I am fixing on Tuesday. Let it come on. I will hear on the matter. Better because that's why because now only I want to see with regard to the LOC and what is the stage? What is the stage of? Let it come on Tuesday.
Your Lordship, we have completed.
Yes.
Your Lordship, we have completed the investigation in this matter. The petitioner is charged under 447 of Companies Act, and we have already submitted the report to MCA. We are just waiting for the prosecution sanction.
Correct. You come on Tuesday, bring all the report and a copy of the LOCP, bring on record, bring on Tuesday. I will hear the matter.
Right, sir. Right, Your Lordship, will file.
They can give us an advance copy, so I can also come prepared.
So if
he was told a different story.
That's why I'm asking. Let the report come. Then we'll see to that. The learned counsel for the petition has argued the matter at length, but this court is found that the report is required to be filed by the SIFO. Accordingly, The SFIFO is directed to file the report by Tuesday. That
Your
is
Lordship may kindly direct them to serve the copies of writ petition. We have
10th
not.
of February 2026. List the matter on 10th of February 2026. At the top देखो खाली আছে কি? 10th February. At the top আছে কি না? Huh?
If we can have the email ID of my learned friend appearing virtually, it will serve again. I don't want to. That can be recorded in the order.
बोल दिया 10th February top है ना? 10th February at the top.
Your Lordship may kindly direct them to serve the copies of writ petition.
Motion. You give the your email ID. They will come. You provide the email ID in your what? To whom you will provide? ये उसमें है क्या? email ID है? उनका email ID है?
It is there in the chat box.
Chat box. You give it to the chat box, then it will be supplied to the petition director to serve the copy of the writ application along with the annexes to the learned advocate appearing for the SIFO by email in course of the day. Full list. Can you supply the report by Monday to the petitioner?
Sir, we'll supply by Tuesday on.
Tuesday, then you come. Let me see. Yes. $26. What is the interim order? You are not having. Dada, what is it? It's the appellate side. It is the appellate side. Till today. Where is the order? Where is the interim order? Fifth of February. Though the matter is listed as item number 26. Keep it. Give the copy on the next day when I will take. You saw the copy. Though the matter is listed as item number 26 of the today's list, but due to paucity of time, the matter could not be taken up for hearing. Learned counsel for the petitioner has mentioned the matter and submit that the interim order is till today and prayed for extension of interim order. In view of the submission made by the counsel for the petitioner, the interim order is extended till 27th of February 2026 or until further order whichever is earlier. Let the matter remain in the list. Yes. Now original site. Original site. Item number 24. 24. 11th कर दो. 11th February. 24. हाँ? ना 24 रोकी. अरे वो फाइल में बांध के ले गया. कोई फाइल में ले गया. उससे पहले कोई फाइल था. उन लोग भी ला के ऐसा रख देते ना. ना 26 में नहीं होगा. नहीं उससे पहले वाला में. Yes. So what is your prayer? Ah. What is your prayer in the writ petition? Vacant possession of property, who will give? SBI Bank has to give the property to you. Yes, you are the purchaser. You are purchased through sale, auction. So sale certificate is issued. So have you made a request for possession? To whom? Authorized officer. You are not requested the district magistrate and the police authority for putting you in the position. Correct. You purchased in auction process. Correct. Sale certificate was issued. Possession was not given. Correct. Registration was done. So possession who has not given the possession? Okay. So when you are going to retire? Next month. Okay. I am in. So when the matter is which serial number? 86. Yes. Hmm. Huh? Probate application dismissed for default by this court. Probate application. But probate application I never dismissed for default. So what do you want? So why go to the testamentary suit? No, there is not requirement. Recalling of that order, there is no requirement. Regular bench. Only the order, no, that is not required. If it is a court release, then you come, then we'll see to that. Yes, call the matter.
Will appear for the plaintiff, my lord.
1 and 2.
Yes, ma'am.
My lord, I appear for the defendants.
Yes. The application order 7 rule 11 is rejected. Order 12 rule 6 allowed. CS is disposed of.
Deeply obliged, ma'am.
Obliged.
Item number 3, WPO is dismissed. Next. Six minutes.
But I was on the last occasion showing the master circular.
Yes.
I'll just finish the master circular quickly today. My lord, kindly take volume 4. My lord, yesterday, my lord, I am not taking your lordship back to the facts straight away, my lord. My lord, my respectful submission before your lordship yesterday or the day before yesterday was that every default is not a willful default. Now, my lord, the definitions at page 561, which is a part of the master circular.
Yes.
My lord, kindly take 2.1.3 at page 561.
Yes.
Willful default. A willful default would be deemed to have occurred if any of the following events is noted. Now, my lord, kindly make a note of, my lord, A. The unit has defaulted in meeting its repayment obligations to the lender
even, Malad, the word is, keyword is even when it has the capacity to honor the obligation. So, Malad, pausing here for if I don't have the capacity to honor the repayment obligation, then I am a defaulter, but I am not a willful defaulter.
Because you have no money.
So because if I don't have the means, see, my funds do not permit repayment. So this is exactly what had happened in this case. Then, my lord, kindly take B. Unit has defaulted in meeting its repayment obligations to the lender and has not utilized the finance from the lender for the specific purposes for which finance was availed of, but has diverted the funds for other purposes. So if the money has been given to me for operational reasons or for, say, opening of letter of credit, but instead of opening letter of credit, I have utilized it for other purposes and I have diverted the funds to XYZ, event of default. Similarly, my lord, unit has defaulted in meeting its repayment obligations to the lender and has siphoned off the funds so that the funds have not been utilized for the specific purpose for which finance was availed of, nor were the funds available with the unit for the fund of the asset. Then the unit has defaulted in meeting its repayment obligations to the lender and has also disposed of or removed any movable asset. This is not their case. So far as for our purpose, my lord, kindly take diversion of fund, which is 2.2.1.
Yes.
Now, my lord, before I take your lordship to diversion and siphoning of funds, yes, which is, my lord, your lordship will say, if I may just trouble your lordship once, if your lordship comes back to 2.1.3, clause B is diversion, diverted, and clause C is siphoning. So these are the two. Now, these two is now been defined. What would amount to diversion? So, there has to be that I had the means of repayment, but instead of repaying, I have diverted or siphoned. Now, what would amount to diversion and siphon? That comes at 2.2. Now, before your lordship takes 2.2, kindly take the concluding paragraph of 2.2.3, 2.1.3, the previous one, the 4 events of default which has been given. My lord, kindly take that paragraph once. Before 2.1, the identification of the willful default should be made keeping in view the track record of the borrowers. My lord, kindly make a note of this, track record of the borrowers, and should not be decided on the basis of isolated transaction incidents. The default to be categorized as willful must be intentional, deliberate, and calculated. 3 adjectives, not 1. Intentional, deliberate, calculated. So, my lord, so logically, if it is not intentional and it has happened in the usual course of business, even if I have not been able to repay, no doubt, it would not qualify to be an event of default, willful default, within the meaning of the master circular.
No, intentional, how the intentional can be proved?
That means money is there,
Correct.
fund is there.
Correct.
Instead, what I do is that I take away, say, 100 crores and send it to some other organ. I invest in some other company.
Correct.
So basically, you are not repaying my debt
Siphoning out.
and instead diverting that same fund. So it was an intentional act not to pay. So that becomes an event of willful default. Now, my lord, kindly take diversion, which is 2.2.1. The term diversion of fund referred to in paragraph 2.1.3b. So I said, my lord, B and C is relevant for our purpose. This is B. Should be construed to include any one of the under noted circumstances. Well, unnecessarily, I'll not trouble your lordship with the others. I'll trouble your lordship with C and D. Kindly take C. Transferring borrowed funds to the subsidiaries, group companies, or other corporates by whatever modalities. So if I transfer funds to my subsidiaries or group companies, that would amount to diversion. Then D. Routing of funds through any bank other than the lender bank or members of the consortium. May not kindly make a note of this, without prior permission of the lender. So, if I have transferred borrowed funds, or if I have transferred funds through any other bank other than the lender bank without prior permission, that would also amount to an event, or it would also qualify to be a diversion. Then my lord, also take E.
No,
E-
then the question arose. Then come to C.
Yes.
Transferring borrowed funds to the subsidiary group companies or other corporates by whatever modality.
Correct.
Correct. You are
Yes.
giving this.
Yes. I could have invested in equity.
If
Then.
if that amount is transferred by you
Yes.
through the bank member concerned without permission, if you're transferring the amount from this bank, so what would happen?
Yeah, understood. So my lord, there can be two issues. One, this routing of funds through other bank means what? Receivables. This is more on receivables. If I have funds receivable, so when the receivables come, so that receivables are adjusted against repayment. So that's the process, that all receivables should come to the designated bank account. So he said that if you have any other bank account, if you open, your receivables come here. So we don't know how much of funds you are collecting by utilizing our funds for the purpose of your business. Yeah, otherwise what fell from your lordship, then it will be mutually destructive, C and D. Then my lord, kindly take E. Investment in other companies by way of acquiring equities, debt instrument without, no, my lord, kindly make a note of this. Approval of lenders. So if I have done it with their approval, no event of default.
Correct.
So
Investment in other company by way of acquiring equities.
So my lord, so if your lordship will see, one is transferring, routing funds, and investment without approval. My lord, why does it say approval? Now, your lordship will, as we proceed, your lordship will get to know, my lord, from the approval notes as we place. Then, my lord, if your lordship will kindly come to now, my lord, I will now take your lordship to the show cause notice ones. My lord, kindly take the trouble of looking at volume 1.
Yes.
My lord, the show cause notice starts at page 112. I'll stop whenever the judge wants to.
Yes.
My lord, 112. But they are saying 330. I said, I'll stop when the judge wants me to stop.
Yes.
My lord, kindly take 113. I'll straight away indicate your lordship the events of default. So, my lord, if your lordship looks at the master circular, the events of default, so the event of default under which they have alleged willful default is 2.1.3b, which is diversion of fund. They say, my lord, they have quoted 2.1.3b. Then, my lord, kindly see the allegation of event of willful default, which is the next column, transferring borrowed funds to the subsidiaries, group companies, or other corporates by whatever modalities. Then, my lord, kindly take the particulars. As per the audited balance sheet of the financial year 2016-17, the company has made advances to its group companies, including other overseas subsidiaries. The details are given below. So they say in FY financial year 2017, I have made advances to my group companies and overseas subsidiaries to the extent of 47 crores.
Yes.
And in 2018 to the extent of 48 crores. Then, my lord, kindly take the sentence after that. As per the audited balance sheet of the company for financial year 17, the company had made investments of 47 crore in the aforesaid group companies, and the promoter directors did not liquidate any of their investments. How do I liquidate investments? As per audited balance sheet of FY18, the investments in these group companies either showed an increase in investment in these companies or remained same as per the previous financial year. Now, then comes additional loan. Allow me to first complete the events of defaults, and then I'll take your lordship to our responses to one by one the events of default. Then, this is number one. The number two is additionally loans were raised by the company from other financial institution and NBFC. There is no bar. Your lordship will see the master circular. There is no bar.
Those were raised by the company. Yes.
From other financial institution, other banks, I have raised loans. There is no bar in law. There is no bar under the master circular. Does not qualify to be an event of willful default without the consent of the consortium lender. Then, further, the loans were secured by the shares of other companies.
Yes.
Pledge of shares of McNally Bharat Engineering Company Limited, in which EMC had invested from their cash accruals mentioned in the balance sheet of FY 17-18. So we're not pausing here for a moment. What they are saying is that I have invested in the equity of McNally Bharat, and my equity in McNally Bharat, this company, I have pledged with third-party financial institution or other banks. So I have read out all the events provided under the master circular. Well, I haven't found
Whether
how
that is a condition or not.
Yeah, this is remotely not does not in any way concern an event of default. Even if I have done that, though I haven't, mentioned in the balance sheet of 2017, note 15. Also, ROC search report revealed loan from ILNFS and IFCI Limited. So I have taken loan from the other institutions. Further, unsecured loans were paid without bank's approval. So payment of unsecured loan without bank approval is not an event of default under the master circular. Details of term loan as on October 12, 2018 is given below. This is according to them the term loan details of 2018. They have given several term loans to the extent of 219 crores. Our simple answer is no bar under the master circular. So could not have been an event of willful default under the show cause.
Yes.
Then, my lord, kindly take immediately after the chart the sundry debtors amount submitted by the company for availing DP, which is drawing power, in their cash credit account showed a drastic decrease during CIRP process. Now, my lord, as your lordship, I had indicated to your lordship, my lord, this company, which is the principal borrower company, went into CIRP. I'll give you lordship the date. 12th of November 2018. 12th of November 2018. So, my lord, if my drawing power in their cash credit account has gone down drastically, but is it the company to blame? Because as your lordship knows, once it is admitted in the insolvency, my lord, initially the interim resolution professional, thereafter the resolution professional takes charge of the company. So the board becomes the suspended board of directors. So I have no role in the management on and from, my lord, the date is 12th of November 2018. So on and from 12th of November 2018, I have nothing to do with the company so far as the management is concerned.
RP appointed.
RP appointed. They say that. The next sentence. The RP apprised, your lordship sees that immediately the next sentence.
Yes, RP apprised.
The RP appraised that only 1% of the sundry debtors were realizable. The sundry debtor amount shown was mainly of the jobs performed by the subcontractors of EMC for which the payments were directly made to the subcontractor by the beneficiary. As such, the company directors, promoters were involved in submitting bogus sundry debtors to avail full DP of the cash credit amount sanctioned by bank. Well, kindly have a look at the master circular, even assuming for the sake of argument whether the allegation is true and correct. Even assuming for the sake of argument it is correct. Would that remotely qualify to be an event of willful default under the master circular? It does not come within diversion. It does not come within, what is the other one? Siphoning. And it does not come within 2.1.3 also.
Yes.
It is not a case of rerouting. And it has been specifically under the master circular, the events have been specifically provided. These are the events which would qualify to be an event of default, not otherwise. Then, my lord, kindly turn to the next page. Central Economic Intelligence Bureau report dated 13th February 2019 stated that the Central Excise Department had filed a report stating submission of bogus billing of the company during 2018. So, my lord, pausing here for a moment, as your lordship is well aware, my lord, if you are referring to a particular report in a show cause, it has to be, you have to be served with a cause, not served. Though, my lord, we are not in any way pursuing this point because subsequently the recommendation was not based on this. So in the order of the identification committee, they did not take this into consideration. So with that Mahinder Singh Gill principle, if we apply, so since this did not form a part of the recommendation process, it is not necessary. But in any event, this lordship can make a note, this was not given to us, though referred in the show cause. Then, my lord, kindly come to 2.2.1d. Routing of funds through any bank other than the lender bank or members consortium without prior permission of the lender. Here, my lord, effectively what they say is, my lord, kindly see the particulars. In the consortium meeting held on such and such, Mr. Such and such confirmed that the company is not maintaining any current account outside the consortium. However, the company is maintaining a current account with HDFC Bank without permission of the lenders. IDBI has approached HDFC such and such and has requested for bank statement for 3 financial years, informed that they did not share the details of their customer without customer consent except with compulsion of law, that is specific order, court order directing bank to do so. The letter from HDFC confirms that EMC Limited is having account with HDFC, which such and such did not reveal during consortium meeting held on 2018. Dealing group is of the opinion that since current account is being maintained with non-lender bank, part of business transaction may have been routed through the said bank account, which can be considered as routing of funds through any bank other than lender bank members without prior permission.
So no evidence.
No evidence. It's a presumption. In any event, my lord, I will show from our reply, but we've indicated and we've put documents on record to show that the HDFC bank account was operational from much before the sanction was given by the bank. It's an old account of mine which continued. So when at continuation of the old account, so here it says that opening of a bank account without prior permission. So I did not open an account. Prior permission would have required if I had opened an account. This was a subsisting account when you granted me the sanction. So, my lord, I don't come under the purview of 2.1.1d. 2.2.1d.
Yes.
Because 2.2.1d says opening of a bank account without prior permission. So I did not open an account. Account continued.
The account is prior to this.
Prior to it. So it's a continuation. It's a continued account. Then, my lord, the last allegation is 2.2.1e. Investment in other companies. An amount of 2.71 crore was transferred from cash credit account of EMC to McNally Bharat. My lord, which your lordship has seen earlier, which shares were pledged during April 2016. It is observed from audited financials of 2018, that EMC has equity investment in ME, which is McNally Bharat, for an amount of 113 crores. The investment is also getting reflected in audited financials of 16-17, which was duly accepted by, kindly make a note of this, my lord, which was duly accepted by SBI lead bank and lenders for assessment during renewal enhancement of limits.
Correct.
So in view of the above, construed that the company invested in other company without prior approval of lenders. So contradictory and inconsistent to start with. So this investment you say was approved by the lead bank and the consortium lenders, and you are one of the consortium lenders. Well, there were 13 banks. They are one of the lenders. And the lead bank of the consortium is State Bank of India. They themselves said that. So this investment was made with the approval of the lenders and was approved by the lead bank SBI. I will show you that document. Well, this is what the show cause notice is. Now we have to start with the reply and the appraisal notes.
So you will continue?
No, any day convenient to your lordship.
Kindly fix 2 consecutive days so that we can finish.
After Mr. Desai also to address my lord. I will not repeat what is my lord, at least on the constitutional point, but there are factual aspects to that.
I hope Mr. Best it is in
No, I will not.
said I hope.
No, you are suffering an interim order. You have been saying that at the time of the release of the matter only you said that. You have chosen not to file an appeal. You have a right of intra-court appeal. You did not. Why did you not file an appeal?
It does not bar me from it.
And I'm a counsel for the petitioner in the
Where are you from saying that to expedite the
25 of 2024 has argued the matter at length, but due to paucity of time, hearing could not be completed. List. Right. PPM 345 कब है? 19th and 24.
Well, 19th I am not there, my lord.
24 are?
Oh, 19th of
19th
March. Oh, very yes. I am there.
February.
No, I am there.
19th February you are not?
No, I am not. Well, 19th March I am there.
Kindly give
I am
me
there.
in February, my lord.
I am there.
24th
I am
February
there.
or 24th and 26th February at 3:45.
24th and 26th.
24th and 26th.
26th Feb.
Very well. Very well. 24th, 26th. 3:45. Very well.
I'll take that one an email ID from Lordship's officer, my lord.
Did आया?